Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
You will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican po, he's verbis Latino. I didn't ask you to interrupt me.
Is that correct?
Literally not true. Oh, for crumb's sake.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. It's good to have you here this morning. Hope you're all doing fabulous. Fabulous. Happy Tuesday to you. Good to be here this morning. Let's see who's here. Shauna C. Shauna C. Congratulations, first in chat today. We're going to punish you. Everything IP related worldwide is your responsibility. You're an old hand here, so you know what the drill is. You knew what was coming to you when you said hi. So everything IP related is your responsibility worldwide. But you're going to do great. You're going to do great. Welcome. We have a little bit of catch up to do for Judge Boyd. We're skipping jury instructions, and we're going to go straight to closing arguments. But we have to hear a little testimony first, so we have to sing happy birthday. Did it work? Nothing's arrived yet, but it mostly feels better. Like, I think I'm good. I don't need the pantyhose. All right, if you don't know what the pantyhose are about, you missed yesterday, and boy, what a day. All right, we are going to be heading back to Texas in just a little bit. Thank you very much, Teresa C., for the gold coin. All right, good morning. Any birthdays today to celebrate? Crazy Chase in LA right now? That's like a Tuesday. It is Tuesday for them. We might have to look at that after the fact. Happy birthday to Cheryl IFL. To Cheryl FL. Cheryl in Florida, I think is what it is. So we're going to sing happy birthday to Cheryl. Everyone, wherever you are, stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. La 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 la. That'll do. Happy birthday to you. Happy birthday to you. Happy birthday, dear Cheryl FL. Happy birthday to you. Cheryl in Florida, happy birthday. There are many wonderful days, but today of all days is your special day. And I realize there are a million places you could be and a billion people you could be with, but you chose to be right here with us. The privilege, pleasure, the honor. The joy, that's ours. Hopefully you can turn that joy right back to you, make your day a little more special. And begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlop's House, Sandy's Grill, Bob Evans, and Cracker Barrel. Now what I'm going to do for the next 3 verses. Everybody is looking at me crazy in this bus as I stood up to sing happy birthday. Even the wise, they're the strange ones. They're missing out. You're the normal one. It's okay. Just keep singing. Keep singing. Don't forget to do the air drums, too. Cheryl says, I'm driving around getting all my freebies today. All my freebies. Cheryl, you should. There's pancakes after pancakes. Enjoy. Happy birthday. Unk alert. We have an unk alert. What is an unk? Am I the unk?
Happy birthday.
Happy birthday. You look great. You can't end the birthday song too soon. That's right. I need to give you a shout out here to bring more subscribers. Do the air drum solo. Here we go. Very good job, all of y'all. We have to jump back to court right away because Judge Boyd is moving ahead this. I thought she was going to start later, honestly. It surprised me, so I thought we had to do a late start. But no, she's moving. She's moving and shaking, getting this done. So we're going to jump to court right
Lorenzo
now.
Calderón. Lorenzo Calderón.
Caldero, what? That's the name of the witness. I think this is I believe the only witness the defense has called so far. This first witness. Best birthday celebration with you guys today, Cheryl. Thank you very much. Appreciate it. 29 months makes you an OG. Happy birthday. Happy birthday. Oh, and we're going to watch this fast. Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God? Yes? See? Okay. Here we go. We're speeding it up. Meanwhile. Why do we not hear this? Shouldn't we hear this?
Are satisfied beyond a reasonable.
No, that's jury instructions. That's what's going on right now. Donnie Nut Wahlberg, member for 2 months. Thank you, Donnie. Thank you. Welcome. I think you've been here longer, though. Hearing nothing. He's getting some instructions of some sort. There we go.
All right, ladies and gentlemen, the state has rested. Defense, do you have any witnesses?
I do, Judge. I call Lorenzo Calderón Gonzalez.
All right.
Lorenzo
Ladies and gentlemen,
Calderón
Mr. Calderón
Gonzalez
is being represented by attorney Cornelius Cox. Mr. Calderón, if you could raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, I swear.
All right, you may lower your hand. And if you'll state your name for the record.
It's always good when your witnesses
Lorenzo
have
Calderón
lawyers.
Gonzalez.
Lorenzo Calderón González.
All right, defense, you may proceed.
Good afternoon, Lorenzo. Buenas tardes.
Good afternoon.
I need to ask you some questions. And if you have any questions regarding my question, any concerns
You
or
need to
something,
ask me a
you have
question.
your attorney there, Mr. Cox, okay?
Tiene que contestar en voz.
Now, you're currently sitting in the Bexar County Jail, correct?
Sí. Yes.
Now I'm
And
in
that's
the
on the
courthouse.
charge of aggravated assault with a deadly weapon?
Sí. Yes.
Whoa.
And regarding your past, you have a prior conviction for assault bodily injury family, don't you, back in 2021?
Was this the other suspect?
Sí.
Yes.
Do you know who Ayden Hernandez Rivas is?
Lo conocí en la unidad que estaba.
I met him at the unit that we were
Okay. There at the jail?
in la cárcel.
Sí.
Yes.
And did you meet with him last night somehow?
¿Usted lo vio anoche? ¿Estuvo con él anoche?
No, lo vi en la mañana.
No. ¿Esta mañana?
Sí.
No, I saw him this morning.
And when you saw him this morning, did you have a conversation with him?
No.
¿Platicó con él? Espérese aquí yo acá. No.
Did you ever have a conversation with Ayden Hernandez Rivas regarding him testifying at a murder trial
Testificar
last
en
week?
En un caso de asesinato la semana pasada.
No.
Diríjase ahí. No.
No.
Okay. Did Ayden Hernandez Rivas ever tell you that he committed a murder?
¿Cometió un asesinato?
Sí.
Yes.
Tell this jury how that conversation came
Pasó
about.
esa plática. Explíquele.
Ya ve que cuando llegas a la cárcel, en una unidad,
You know that like when you arrive at jail, at a certain unit,
todos tienen la costumbre de preguntarte por qué estás ahí,
we all have the habit of asking the other people, why are you here for?
qué es tu cargo,
What did they charge you with?
y se pregunta cosas así, qué es tu cargo, por qué estás aquí, y ya le dices tú,
That's the questions we ask. Why are you here? Why did they charge you for?
ya te dicen qué cargos tienes, ya les dices, tú les platicas.
And they ask you the same thing, so that's the way you talk.
And that's just out of curiosity, right?
Sí.
Yes.
Okay. And did you have that conversation with Ayden Hernandez Rivas at the jail?
Sí.
Yes.
Sí.
And in that conversation, did he tell you that he actually was the one that committed the murder?
Sustained.
In that conversation, Mr. Calderón Gonzalez, with Ayden Hernandez Rivas, tell this jury what he said to you regarding the murder case.
Ok. A mí me preguntó que por qué yo estaba allí.
He asked me why I was there for.
Ya le dije mi cargo por asalto grabado,
I
arma
told him my
mortal,
charge, aggravated assault with a
Lo-
deadly weapon,
lo cual nunca hice nada. Y yo le dije a él, nomás lo único que le dije al muchacho con el que argumenté,
permítame, which I never did anything. I told him, the only thing that I told the guy that we were arguing with,
le dije, no me molestes.
I said, don't bother me.
Y él habló a la policía
He called the police.
y le dijo que yo traté
But
de...
Mr. Calderon, you're talking about
Could I
your
have
case,
parties
right?
approach, please?
Usted está hablando sobre su caso, ¿verdad?
O sea, lo que yo le expliqué.
Okay, so they asked him a question about what Mr. Ada says. He's like, so we all get to jail. We're like, hey, what are you in for? And he's like, what do you get charged with? And he's like, well, I got charged with assault with a deadly weapon, but I did. But I didn't do it. And he's like, oh, what happened was, and he's cutting into his story, saying, I'm innocent, instead of talking
All
about
right, sir.
Adis.
Señor,
You need to listen to the question that's asked of you and only answer the question that's asked of you. Do you understand?
entiende. Yes.
You are not allowed to talk about what you think the facts are in your case for the aggravated assault with a deadly weapon. Do you understand?
Entiende. Yes.
Ladies and gentlemen, you're to disregard any testimony by this witness about the facts or what he believes the facts are in his aggravated assault with a deadly weapon case. Does everyone understand? Is everyone able to do that?
Yes. Yes,
All right,
Judge.
defense.
So Lorenzo, we're only here to talk about Adis Hernandez Rivas, not your case.
No tu caso.
What did Adis, if anything, tell you
But I'm
regarding
innocent.
his murder case?
Respecto al caso de él, del asesinato.
Yo le pregunté a él, ¿por qué estás tú aquí?
I asked him, why are you here for?
Entonces él me dijo, por una muerte.
And he said, because of the murder case.
Y yo le dije, ¿y lo hiciste? Dijo, sí,
And
lo
I
hice.
asked him, did you do it? He said, yes, I did.
And when you had this conversation with him,
Platicaron esto.
was it very clear to you that you were asking him if he committed the murder in his murder case?
El asesinato. En este caso de asesinato. Se estaban hablando de este caso de asesinato.
Sí.
Yes.
And he said yes.
Y él dijo sí.
And when he said it, he
Got a
wasn't
good
joking, was he?
translator.
Y él no estaba jugando, bromeando.
No.
No, he wasn't.
So to you, he meant that he committed the murder
Quiso decir
in the murder
que
case that he's part of.
y cometió el asesinato en el asesinato de
I'm going to object as to speculation.
Sustained.
I'll pass the witness.
State.
Sustained
Um,
pass.
What unit did
¿En
this
qué
occur in?
unidad ocurrió esto? ¿En qué unidad?
CH, piso cuarto.
CH, fourth floor.
And you're saying this occurred this morning?
Esto ocurrió esta mañana.
No. Yo lo vi en la mañana cuando me llevaron a Booking.
No. I saw him this morning when they took me to booking.
Okay. He wasn't in booking this morning.
No, yo estaba en Booking en la mañana y luego ya cuando me regresaron para la celda, él iba en los elevadores abajo en Booking
No, I was in booking, but when they took me back to my cell, he was in the elevators.
y él me dijo, hey,
And he said, hey,
Didn't you just tell this jury
acaba de usted decir al jurado
that it happened in the housing unit
que pasó en la unidad de
and that it's normal for people when they arrive to the housing unit to ask, what are you here for?
Preguntan por qué estás aquí.
no, yo lo conocí en CH
I met him
hace 3 meses y medio.
like 3.5 months ago in CH.
Y ahora, de esta mañana,
And this morning, this morning,
cuando me mandaron a Booking para cambiarme,
when they sent me to booking to change my clothes,
yo estuve esperando ahí para que me trajeran a corte.
I was waiting there so they can bring me to court.
Después me dijeron que la cancelaron.
That
Then
makes
they
sense.
said that they had canceled it.
So, me mandaron para atrás a
Sí.
cambiarme.
They sent me back to change my clothes again.
Y yo cuando iba a los elevadores, él iba a agarrar también el elevador y
So when I was in the elevator, going to the elevators, he was going to get the same elevator.
él dijo, hey, nomás me dijo
And he
así.
just said, hey, that's it.
Okay. So when did the conversation, because you told Mr. Garcia, and let me finish my question before you answer, okay? You told Mr. Garcia that this conversation about the murder happened in a housing unit. Do you recall saying that?
¿Se acuerda haber dicho eso?
Sí.
Yes.
Yes. So you said that you met,
Dijo que usted lo
this conversation happened in the housing unit. Which housing unit was that?
en una unidad de housing. ¿En qué unidad fue?
CH, cuarto piso,
CH,
hace 3 meses y medio.
fourth floor, 3.5 months ago.
Okay, because you're currently housed in unit HA, not CH, correct?
CH.
CH.
Okay, the jail records say that you're currently.
Object, Judge, to the question. He's already answered the question. What he's asked.
That objection will be overruled.
Okay, so what unit are you currently housed
unidad
in?
está ahorita usted?
AJ.
AJ.
AJ?
AJ.
Okay, so you're saying that the Bear County Jail has it wrong, that they have you housed in unit HA,
Que lo tienen en unidad.
that the records are wrong. Is that what you're telling the jury?
¿Es lo que está diciendo usted al jurado?
Cuando conocí a Aris, estábamos en la CH.
Not
When I met
asking
Aris,
you.
let me translate this. When I met Aris, we were on the CH unit.
I'm asking you where you're currently housed right now.
Ahorita.
AJ, sixth
AJ.
floor,
Sixth floor.
Okay.
En español, señor.
piso 6.
Sixth floor.
Okay. So you're saying that the Bexar County jail records are wrong because in your file, it says that you are housed in HA.
No,
No, okay. And you're currently housed in the same unit as the defendant Marco Moreno Vasquez, correct?
correcto.
And the truth is, you've never been housed with Ayden Hernandez Rivas, correct?
Estábamos en CH.
We were in CH.
Okay. Again, I'm gonna ask you, because the jail has sent me the records. There is no record of you and Ayden ever being housed
I'm
together.
going to object to her testifying, Judge. He doesn't know where Adis was, and her reading off of some screen or paperwork has no effect on what he knows.
It's
All right.
certified.
The objection will be overruled.
So like I said, the jail has sent me the records, the classification record. You and Ayden Hernandez Rivas have never been housed
I'm
together.
going to object for her testifying for something that's not in evidence.
All right, with regards to, you can ask your question, but regards to testifying, that'll be sustained.
Well, tell me this, what does Ayden Hernandez Rivas look like?
¿Cómo se ve Ayden Hernandez Rivas? ¿Con qué apariencia tiene?
Es morenito, así como un poco más blanco que yo,
He's dark skinned, a little bit whiter than me.
ojos rasgados, hondureño,
He's from Honduras. His
Tiene un
eyes are like oval shape.
tiene un tatuaje, no sé si aquí o aquí, de un tecolote.
He has a tattoo of an owl. I don't know if left or right.
Okay, and so I just want to clarify, you're saying that this conversation where he told you,
This is crazy.
you asked him, what is he in Bexar County jail for, is that correct? And he told you,
Yes.
I'm sorry, and he told you for a murder, is that correct?
Sí,
Yes.
Okay, and you asked him if he did it,
sí,
and
Yes.
he said yes.
Sí.
Okay.
Yes.
And you're saying that this conversation with him occurred in unit
En la unidad
CH?
CH.
sí.
Yes.
Okay. But I'm gonna ask you the question again. You were never housed with him.
No,
Okay. You are currently housed with the defendant Marco Moreno Vasquez, correct?
no estamos en la misma celda.
We're not in the same cell now.
Are you in the same housing unit?
Sí,
Okay, so that means that when you guys get your break and you get to come out of your cell, y'all all get to congregate in the tables that they have there in the Bexar County jail, right?
correcto.
Right.
We pass the witness.
Defense.
Wait a moment, Judge.
So, do we believe this, the jailhouse snitch here, who says that 3 months ago they were housed together, even though their jailhouse records apparently don't show that?
Now, Mr. Calderon Gonzalez, do you know me at all?
¿Usted me conoce a mí?
No,
No.
And nobody's promised you
Nadie le
anything
ha
to come and
prometido a usted
testify,
nada.
correct?
nada.
Nothing.
And you were sworn to tell the truth,
Ustedes lo
correct?
pusieron bajo juramento para decir la verdad,
Sí,
¿cierto? Yes.
correcto.
Right.
And so by testifying here today, you get nothing out of it.
No gana nada,
Is that
¿verdad?
correct?
No, correcto.
Nothing. That's right.
You're just telling the truth.
Usted solamente está diciendo la verdad.
Correcto.
Right.
And no matter what questions the prosecutor asks you as to where in the jail you're housed or how you ran into Adis, you can tell the jury that you ran into him, correct?
I'm object to leading.
Sustained.
You ran into Adis several times throughout the time you've been sitting at that jail.
I'm object to leading.
Sustained.
Approximately how many times have you run into Adis Hernandez Rivas at
veces
the
te
jail?
encontraste con Aidas en la cárcel, que se vieron así afuera. ¿Cuántas veces?
Estábamos en la misma unidad, en CH,
We were in the same unit, the CH unit,
hace 3 meses y medio.
three
Y
and a half months ago.
cuando estamos en la celda y cuando dicen freeze off, entonces salimos al day room y ahí nos ponemos a jugar barajas.
So when we're in our cell and they say freeze off, then we go out and play cards in the common area.
And that's where you met him.
Ahí es donde lo
Sí.
conoció. Yes.
And is that where you had this conversation with him regarding him admitting to you that he committed this murder?
admitir que él había cometido este
Recién que me movieron a CH y fue cuando él me preguntó lo mío y luego yo le pregunté lo de él.
Yes,
Sí.
recently when was moved to CH, he asked me about me and I asked him about him. Yes.
Does everything at the jail move like
En la
clockwork?
cárcel, todo en la cárcel va como un reloj, el horario y todo.
Like clockwork?
Sí.
Yes.
Do they ever get things
Alguna
wrong?
vez
Have you ever
hacen
been
cosas
brought down to meet with
equivocadas.
your attorney
A veces
and
lo
you're the
van-
wrong guy or it's the wrong attorney?
Object to speculation and
resulta que usted no es el
All right, with regards to relevancy, that will be sustained.
You're certain you met with Adis Hernandez Rivas, correct?
Se vio con Ayden Hernandez Rivas, ¿verdad?
That's leading.
Usted se vio con él, ¿verdad?
¿Cuándo?
When?
At some point while you've been sitting in the jail.
Estaban los dos en la cárcel.
Ahí pues, estamos en la misma unidad.
Yes, we were in the same unit.
And you know what he looks like.
Y
Sí.
usted sabe,
You described him for the DA.
lo describió
Sí.
para
And
la
President
fiscalía
Fury.
y para el jurado.
Correcto.
Right.
And there's no doubt in your mind that he admitted to you that he committed this
Yo que
murder. Am I
cometió
right?
este asesinato, ¿verdad? No te queda ninguna duda.
Correcto.
Right.
Nothing further.
Esto,
No further
señoría,
questions.
son todas mis
All
preguntas. Muy bien.
All right.
And can I have parties approach?
Okay, that is going to that's going to complete it for yesterday. What we missed. There's nothing else. I don't believe the witness. Did the Elmo picture get bigger in the past? It's maybe the zoom brought it closer. I'm gonna skip forward a little bit. I think that's the end of the day. Yeah, he gets up, he leaves. She's done. We're gonna go up here to today, where we're waiting.
Yes, sir. Yes, sir.
Yes, Your Honor.
All right, State, you may proceed.
Now we've got closing arguments. We're sped up right now while we catch up just a minute or two. Hope you don't mind.
Ladies and gentlemen, as Judge just read to you, this is the charge of the court. This contains all of the law that you will be able to take back with you to conduct your deliberations, and you are bound to the law herein. We're going to go through the elements of the charge and break down everything you have to deliberate. So we're going to start with the law. Here, Mr. Moreno Vasquez is charged with 2 counts. Count 1, murder, and count 2, deadly conduct. Now, murder is separated into 2 paragraphs, meaning there are 2 ways by which he's charged with murder. Paragraph A's elements are that on or about a date, February 16, 2023, in Bexar County, Texas, the defendant, Marco Moreno Vasquez, did intentionally or knowingly cause the death of Duño Valadares Fernandez by shooting Duño Valadares Fernandez with a deadly weapon, namely a firearm. Paragraph B's elements are on or about February 16, 2023, in Bexar County, Texas, the defendant, Marco Moreno Vasquez, did intend to cause serious bodily injury and commit an act clearly dangerous to human life that caused the death of the complainant, Duño Valadares Fernandez, by shooting the complainant with a deadly weapon, namely a firearm. Now, it's important to remember, as we discussed in voir dire and as the charge states, that a deadly weapon, being the firearm, a firearm is per se a deadly weapon, okay? And it says that in the charge. Now, count 2 is deadly conduct with a firearm. And the elements of this count 2, are that on or about February 16, 2023, in Bexar County, Texas, the defendant, Marco Moreno Vasquez, knowingly discharged a firearm at or in the direction of a habitation and was reckless as to whether the habitation was occupied, in that he failed to make adequate inspection and inquiry regarding the presence of individuals therein, okay? Now, we're going to go over the mental states. Remember, you're not required to be mind readers, okay? You may make inferences based on words, actions, and the surrounding circumstances. In the charge, it discusses the 3 mental states, the first one being intentionally. Someone acts intentionally when there is a conscious objective or desire to engage in the conduct or cause the result. Okay, as Megan told you in jury selection, you can ask yourself, did you mean to do that? That's when someone acts with intent. Now, something is done knowingly when the individual is aware of the nature of his conduct or the circumstances that exist. Did you know what you were doing when you did that? And finally, recklessly, you act recklessly when you are aware of but consciously disregard a substantial and unjustifiable risk that the result will occur. Did you know there was a big risk that could happen when you did what you did, but you did it anyway? Now let's discuss the law of parties. So a person is criminally responsible as a party to an offense if the offense is committed by his own conduct, by the conduct of another for which he is criminally responsible for, or by both. Now, a person is criminally responsible when they're acting with intent to promote or assist the commission of an offense, that he solicits, encourages, directs, aids, or attempts to aid the other in the commission of that offense. Now, the accomplice witness rule. An accomplice witness means any person if they participated in the offense before or during its commission, and they can be prosecuted for that same crime. Now, here, you must first believe that the accomplice witness's testimony, so here, Audis Hernandez Rivas' testimony is true, and that the defendant is guilty of the crime, and then further believe there is corroborating evidence intending to connect Mr. Marco Moreno Vasquez with that offense. Now remember, ladies and gentlemen of the jury, testimony is evidence. And in this case, you saw a lot of photos, you saw videos, and you heard from numerous witnesses from that witness stand. All of that combined is evidence in this case. And you, though, are the sole juror, exclusive judges of the facts to be proven in this case, the credibility of the witnesses you heard from that stand, and the weight that you give their testimony. You were instructed in the charge that you are not to let bias, prejudice, or sympathy play any role within your deliberations. And you were also instructed that your sole duty right now is to determine guilt or not guilty under the indictment in this cause, and that you are to restrict your deliberations to solely that issue and nothing else. We will reserve the remainder of our time. Defense.
Thank you, Judge.
That was quick.
Good morning. So we're finally at the end of our trial. We started Monday or Tuesday, and you heard a lot in voir dire. And one of the important things, or two of the important things, was you are the triers of the facts. Prosecutor told you that it's in your charge. What does that mean? It means you get to decide of the testimony that the DA brought you, whether you believe it or not. Okay? And you can disregard part of it or all of it if you didn't believe it. Okay? You did not believe it, you can disregard it completely. Why is that important? Because you heard testimony from officers, from civilians, from experts in this case. And you have to look at this case as it's a murder charge, and if you want to just find somebody guilty, find Marco guilty. Okay? But that's not how our system works, right? We're the greatest country in the nation, and one of the reasons
we're the greatest country in the nation. We're the greatest country in the nation.
Marco sits there completely innocent at this point.
The shirt that says that.
The only way he will be found guilty is if when you go back and deliberate, you believe the evidence or part of the evidence and say, you know what?
He's not
beyond
wrong.
a reasonable doubt as to each and every element, I believe that Marco did this. Okay? But by the same token, under your oath, you've got to look at everything. You've got to discern whether you believe it beyond a reasonable doubt. So let's think about the testimony. I was a little hard on the officers, okay? I don't suffer fools lightly. And I'm not insulting the officers. They have a tough job.
Yes, you
all
are.
Of them. When we're in trouble, if I'm in trouble, if I can't defend myself at that moment, I want the police to help me, just like anyone else. But by the same token, there are rules under our Constitution that must be followed to you, to me, to Marco.
The rules in our country
and
in our nation.
Did they follow those rules? They were a little haphazard, nonchalant about their testimony and what they did. Even the detective that they finally brought at the end, Detective Waits, who's supposed to be in charge of the whole thing, did he say he was in charge of the whole thing? No. It's a team effort, and we kind of put things together. This is the seventh largest city in our nation. Is that how you want investigations to work? Okay. So if I was a little too rough on them, I apologize, but I have a job to do. And that's to protect the rights under the Constitution to Marco here. And I take that extremely serious. And so let's talk about what they brought you. They brought all these people. Think about, of all the people that they brought, who were the ones that didn't have an agenda? Who were the ones that were either just strictly science or had nothing to gain? In this case, they brought you the medical examiner, right? She told you it's all about the science. And does she help us in any way other than tell us that Danielle was killed by a gunshot wound? No. Other than that, that's kind of it. But she also didn't say that there were beating marks on Danielle. There were bruises to his head, to his torso, to his arms, defensive wounds. You didn't hear any of that. And I got that out of Detective Waits. Okay, I didn't have to ask the MA because if there was evidence, they would have brought that out. Remember, it's their job to bring out the evidence, not mine. I'm just pointing out to you what's blatant and missing. That's going to be important when I talk about Aydes's testimony. Who else did we hear from that had no gain in this? The ballistics guy, right? He just does the science of testing the guns, testing the spent shell casings. And here, what he testified was that one of the guns, this one, that the spent shell casings found at the house, okay, where Danielle was killed, there were 4 spent shell casings that were sent to him that matched this gun. Reasonable conclusion? This gun was used to kill Danielle, okay? Unless there's not a bullet that matched, and there was no testimony regarding that. But this gun was clearly used at Danielle's house. Who had this gun when he was shot? We don't know. They're going to argue that it was Marco. Ayden said that it was Marco. Okay, we'll talk about Ayden in a minute. Who else was not biased in this? I submit to you that the daughter, Roxanne, she was 13 or 14 at the time, because this is an old case. What did she tell you? She told you what she saw happen, that her entire family was put in a Suburban, driven by her mother, with Marco sitting in the passenger seat, Ayden sitting in the back seat with the kids, behind the driver. And they drove and they went to Dairy Queen and ate. She was super happy at that moment. Okay? It's kind of a surreal story when you think about this. But life and truth are stranger than fiction. You can't make this stuff up. What does she say next? That they drive over to Danielle's house, whom she doesn't know. She doesn't know this location. And she says her father, Marco, and Ayden get out and they walk to this gate. And she's parked where she can see everything. It's still dark, but she says, I can still see. And she's parked parallel to the entrance where that gate is. The windows are up. It's quiet in there. And she sees an argument. And she sees Danielle pull out a gun that he got from the back seat, the pocket of the back seat that he was sitting in front of, behind that one, and walk out. And that his father walked out with a gun also. Now understand, I don't get to come back after the DA talks. And they're going to be like, aha, that's it right there. He had a gun and he used it. So he's guilty of murder. But what does Roxanne tell us? She tells us that Ayden starts shooting, and when he shoots straight at Danielle, and Danielle goes down. And then her father shoots into the ground, and then they run back. Okay. They run back. This is the witness they put on.
Into the ground where he fell down?
They did. And then they drive straight back to the house in Poteet. And then they drive, she said, to Austin to go to family with Ayden with them. When you look at that story, why would anyone take their family to go shoot someone? That doesn't make any sense. I submit to you, if you look at the transcript that was put into evidence, I believe it's 217, Marco is trying to tell the cops, trying to tell the detectives, and you understand there's a Spanish barrier here, and they had Officer Arias, Sergeant Detective Arias, there to translate. And I asked them, how many times did Marco bring up his family? You have the transcript and evidence. When you take it to the back, take a look at it. 6 or 7 times. And State tried to bring out, well, he was distancing himself from the event. No. He's trying to tell him he's worried about his family. Why would he be worried about his family? And the kicker there is where, in the transcription, he says, look, I'm going to tell you the truth. But is this information going to get back to Ayden? Why would he do that? Why would he be afraid of Ayden finding out that he's talking? And Arias says, yeah, I told him he's not going to know about it, which we all know is a lie. We all know that eventually the bad guy's going to hear about it. And he was in fear for his life, for his wife, his kids, and for himself. And so did he not come out and say, listen, the guy threatened me with a gun, he threatened to kill my family? He didn't, not in those words. But by the same token, you heard from you heard from Lorraine earlier. Okay? What did she say? That she, actually it was not Lorraine, it was the other woman at the scene. And she said she didn't call the police because she speaks Spanish. She called Lorraine to call the police. We all know that the dispatchers speak Spanish. There are signs all over our city in Spanish, but yet there is a barrier. And so that barrier precluded Marco from telling the police, even though he tried, that he was in fear for his life and he was forced. Okay? I submit to you what happened was Ayden threatened him and said, you guys are going to come with me. And what more threatening is there than to make him bring his family with him to make sure he won't talk? Also, you heard from Roxanne that the family went up out of town to Austin, okay, with Ayden. If you're leaving town to get away because you're scared of something bad that happened, why would you take the bad guy with you? Ayden. because he's staying on top of them to make sure that Marco can't say a peep. Okay? It wasn't until Marco got brought in, arrested. You heard the officers from Atascosa who worked with Bexar County Sheriffs, arrested, handcuffed, and taken down to the patrol station to be interrogated. Okay? When he finally starts to say, and at the end he says, Ayden is the one that shot him, which is consistent with Roxanne. Now let's talk about Ayden's testimony. They brought him, who's a co-conspirator, an accomplice, to testify against Marco. But what's the problem with that? I don't think Ayden knows the difference between a truth and a lie. How many times did he lie up there? Numerous. I could have brought Sergeant Arias back and gone through each and every line, but there was no need. Why? Because I brought Lorenzo Calderon Gonzalez, another person with no skin in the game. He wasn't getting any benefit from me. I'm a defense attorney. I have no control over what the DAs do. He was just there to tell you the truth. And what did he tell you? Once again, there was that Spanish language barrier, but the meat of it was that Ayden confessed to him that he committed this murder. Knowing that Ayden committed this murder changes everything, because his testimony is basically, I did nothing, Marco did everything. Marco did it. Marco forced me. If you look at what Ayden said, everything he said was reversed to make him look innocent, when the reality is that was the situation he put Marco in. He threatened Marco. Marco had to go. Marco didn't know why he was going, just knew that he didn't have a choice, and they went down there. Marco didn't drive. Also, Marco's testimony contradicts what Roxanne said. Why would he have said they stopped at a gas station so Marco could get rid of the weapons? We know that's not true. One of the weapons is here in evidence. So that didn't happen. But why did he say it?
Mention the beans.
To try to make Marco look more guilty, that he was trying to get rid of the weapons. What else does Roxanne say? That her mom and dad walked into the house and that they took the gun or guns. Why would they do that? Because Ayden was forcing them to. Ayden had access to that house. He came and went in that house. So he made sure the gun was there so that when the cops finally came, it would make it look like Marco was the bad guy. What else do we know? We know that there's no evidence of DNA, there's no evidence of fingerprints, and there's no evidence of gunshot residue. If there had been, they would have brought it, but there's not. They're probably going to jump on the fact that there were other spent shell casings found at Marco's house, and that shows that he dumped them at his house. That doesn't make any sense. What else did Ayden tell you? That Marco bent over and picked up his spent shell casings from which he fired.
Hey guys, I just had a
Why
power
would he do
flicker.
that?
Did
The
anyone get
evidence
affected
only
by
showed
that?
the 4
Can
spent
you
shell
still hear me?
casings that all came back from this gun. The spent shell casings found at the house that matched that gun weren't from a different gun. They were from this same gun. Ayden had access to that house. I submit to you that taking Ayden's statements, it shows you his real intent. But by the same token, as the jurors of the facts, the triers of the facts, you can discount everything he said. Okay? Completely. Because it's all lies. That leaves you with Roxanne's story and the transcript by Marco. Let's talk about the transcript by Marco. You saw Sergeant Arias testify to. You're going to have States Exhibit 217 back there with you. Look at pages 5 and 6. Remember, this is a country ruled and governed by laws. The police have to follow that law. It's in your charge. They have to read you your Miranda warnings before you give a statement. And you have to say yes to each and every right. When you go through this on page 5 and 6, you're not going to see that Marco said yes to every right. Take it back there and look. I'm not going to waste time on that, because once you see that, his statement was not voluntary, intelligently, or knowingly given. And under the law, you can throw it out and disregard it. But what I want you to have taken from his statement was his fear, to show that he was deathly afraid for himself, but more for his children. And it's in here. if you go through it. I brought out several instances, but there are more. What else do we know? We know that Ayden said he didn't kill Danielle. We know he did. You look at him, he's a stone cold killer. You saw him up there. Did he look at you once?
See it in his eyes.
Not once. He knew he was lying. He even refused to admit that he was lying until I broke him down.
He's a stone cold killer.
The state's going to come back and say, you know what? Mr. Garcia made some good points. Okay. Maybe he wasn't the shooter. But we're going after it for acting in concert. That he was part of the team with Ayden to kill Danielle. Okay. In order for that to happen, they have to prove, and it's in your charge, that he aided, he abetted, he conspired with, he assisted. You take all of the testimony together and the one that you believed happened from Roxana, there was never any talk that he was going down there to assist or to shoot Danielle. There was never any talk about why. They're going to talk about motive, and they brought other witnesses to try to imply, to try to infer that maybe Danielle owed him money. You have the witness who testified about being in Houston with a stack of money. You can't infer any of that. They didn't bring you direct evidence. You cannot let bias, sympathy, any of that come into play just because there's a dead body here. I feel sorry for Danielle. They have the killer, who's Ayden. He'll be sentenced later. But as far as Marco's concerned, he was a pawn. He was a patsy that Ayden tried to use, and used effectively. Now, Marco didn't testify because you heard some of it. And they're going to argue, well, why didn't he say he was being threatened? Why didn't he say any of that? He could have done that because he was scared, ladies and gentlemen. Imagine somebody putting a gun to you and threatening to kill you, your wife, your children. What are you going to do? Are you going to run to the police? Some people would. Other people would be too scared because the most important thing in their lives are their children. So he kept his mouth shut. And he stammered and he said stupid stuff in that interrogation. But the reality was he was trying to get across the point that he couldn't because he was in fear for his children. There was no distancing, which they're going to claim. There wasn't. And so he could have gotten on the stand and said that. But because they failed to prove that he's guilty beyond a reasonable doubt as to each and every element, he felt, and I agree, that he didn't need to because his story was already there. So if you follow your oaths as jurors and follow the law given to you by the judge, you're going to find that you cannot believe that he was a part of this willingly, knowingly, under acting in concert. He wasn't. Remember, under the accomplice witness rule, besides Ayden just being a complete liar, you can throw all that out because there's no corroborating evidence as to Marco being part of a team with Ayden.
You can throw it out because there's no corroborating evidence?
Well, the defense counsel talked about Roxana. That corroborates it, but only as to him shooting down into the ground. You know, they have him charged with murder and deadly conduct. Shooting down into the ground is not shooting at a house. It's not shooting at Danielle. And they're going to say, well, we have proof because of the gun in the refrigerator. You know, ladies and gentlemen, if you believe that he and his wife remember, it's not his wife, it has to be him, put that gun in the fridge at his house, that would be tampering with evidence, not murder and not deadly conduct. And that charge is not before you. Now, you may have questions after the prosecutor gets up and speaks and you go back and deliberate. If you have any questions as to the testimony, and court reporters hate me for saying this, they all do, okay? You have a right to have the testimony read back, but it's very important because there's a rule and you have to follow that rule. You have to tell the court in your question what the issue is And it has to be so narrow as to who or whom said it, so that they can go back and just read that one sliver of testimony. It can't be, I want to hear all of Danielle's testimony. I want to hear all of Roxana's testimony. It has to be very specific and limited, but you have that right, okay? Now, as jurors, when you go back there, it's in the charge. You're going to have to pick a foreperson. So you'll do that, but then you're going to deliberate as to the evidence, as to guilt or not guilty. And on that, you have to hold on to what you believe. That's the beauty of our system. I'm not saying you to be rigid. I'm saying to be strong in your belief. Don't just go back there and if, the person next to you is like, it's obvious he's innocent or it's obvious he's guilty, don't just give in. Make them explain to you why. Because if you have a reasonable doubt as to each or any of the elements beyond a reasonable doubt, that alone is enough to find him not guilty. And I submit to you there are a lot of reasonable doubt. There's a lot of reasonable doubt in this case.
5 minutes.
So I'm just going to push some of the language in the charge.
I doubt there's 5 minutes left. Shelley Small, thanks for the 5 gifts.
Person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. There's no testimony, none whatsoever, that is believable that Marco shot Danielle. Adis, you can disregard him several different ways. Accomplice rule, or just the fact that he's just a horrible liar and is not to be believed. You can completely disregard his testimony. You just have Roxana putting him there, him putting him there in a statement if you don't throw it out, but there's no testimony that he fired at Danielle. The only testimony is from Roxana that he fired down. That's not the conscious objective or acting in concert to kill someone. Law provides a person is criminally responsible as a party to an offense if it's committed by his own conduct, we know it's not, or the conduct of another. So they're going to say he was acting with Adis. Okay. Here, they have to show how. That he solicited, no evidence. That he promoted, no evidence. That he assisted, no evidence. That he encouraged, nope. Directs. Adis tried to tell you that he directed it. Can't believe Adis. Aids or attempts to aid the other person to commit the offense. There's no evidence of that. None. That is believable. So they can't get you there. Accomplice witness. Like I said, there's no testimony corroborating Adis's testimony, which was pure lies. Remember, when you go back, look at pages 5 and 6 of the transcript, because you're going to find that the officers did not fulfill the Miranda rights. And under that, you've got 3, custodial interrogation. We know he was arrested and put in a room. We know he was being interrogated. And they had to read him his warnings, which they did, but they didn't let him answer. That he understood. And on some of them, he said yes. On others, he said, it's not yes. So they failed to have him state something knowingly, intelligently, and voluntarily. And thus, you can throw it all out. Like I said, you can't hold it against him because he didn't testify. You're not to let bias, prejudice, or sympathy play any part. We have a dead person here. But this case is whether they proved that he committed that offense, either himself or acting in concert. They didn't meet that. Here's the most important one. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony. So you have to believe it beyond a reasonable doubt. I submit to you, the testimony they brought, other than the experts in Roxana, you cannot believe beyond a reasonable doubt. The presumption of evidence alone is sufficient to acquit the defendant. Even if he was present, and you believe he was, because Roxana puts him there, that alone is not enough to find him guilty. Whether you like him, dislike him, like me, dislike me, that doesn't come into play. It's the law and what they brought you and what they didn't bring you. And they didn't bring you evidence beyond a reasonable doubt that Marco Moreno Vasquez is guilty of committing this murder either by himself or with aiding with Adis. Thank you for your time. On behalf of Marco and myself, I know you'll go back there, deliberate, and do the right thing.
Find him not guilty.
All right. State.
Should we do a poll?
I don't know. I don't know. I don't know. That was the response, not spoken by an innocent man, but by this defendant who sits here before you today, asking you all to find him not guilty when he knows that he acted in concert with Adis Hernandez Rivas and orchestrated the killing of Duniel Valadares Fernandez. On that day, he put greed over humanity. I told you all that in my opening statement, and I utter it again to you all today. Now, I'm going to turn to the law. Okay, we've talked about intentionally and knowingly. You all know the definition. Will be in the jury charge. But Mr. Garcia argues to you that there's no evidence of intentionally or knowingly. Okay, and so I told you all in jury selection that you all are allowed to infer from words, actions, circumstances, and facts. Okay, so let's look at what that looks like in this case. Okay, what was the defendant's desire on that day, right? It was to go to the location and collect the money that Duniel owed him, not Adis. And you all heard that from Masalud Zugueta, and you also heard that from Roxanne. How did the defendant act knowingly, right? He goes there armed with a firearm, and he knows that Adis is armed with a firearm, because if you believe the testimony of Roxana, which Mr. Garcia has asked you to do, Roxana testified that her dad is the one that provided Adis with that firearm. Now let's talk about the testimony that you all heard in this case. You guys heard from Deputy Maxwell. He testified that he was dispatched to that 7718 Winsford Drive, and he was first on scene. He was dispatched there for a shooting. Okay, he told you all that he observed two females that told him, hey, go to the back, and that when he went back there, he observed Duniel face down, suffering from a gunshot wound. Okay, he started CPR, and then he participated in life-saving measures before turning to his law enforcement duties. Okay, and he told you all that he saw those 4 shell casings that were there in front of the gate, and then he contacted the follow-up unit. You guys heard from Deputy Perez, and he testified the same. He was riding along with Maxwell. He observed 2 females and a male that led him to the back of the location. He also observed Duniel face down, suffering from a gunshot wound, assisted in the life-saving measures, then turned to the law enforcement duties. Now, he testified that he saw the 4 shell casings as well, and that he was the one that noticed that that home was equipped with DVR. Okay, and he inspected that DVR system, and he didn't observe any wires being tampered with or anything of that nature. Then you guys hear from CSI Anderson, and he testified that he was briefed by Deputy Perez. He seized those 4 shell casings, okay, which were labeled as CA 1, 2, 3, and 4, and that has been entered into evidence as State's Exhibit 65, okay? And he also testified that he observed those defects to the home, and he took the photos and the video that has been entered into evidence, okay? You heard from Dr. Ward. She identified Duniel Valadares Fernandez, and she confirmed his identity through fingerprinting. She testified that Duniel died of a gunshot wound to his torso, and that the entry was in his upper back, okay, and that exit was on the left side of his chest, and that she determined the manner was a homicide. Now let's talk about the testimony of Marcel Lucieta, okay? This is another person that had absolutely nothing to gain from her testimony. And what did she tell you? That she was the owner of 7718 Winsford Drive. She knew Duniel, and his nickname was Cubano, that he was there living at the location, and that she was not present during the shooting. But when she arrived home, she observed Duniel in the fetal position. She contacted Lorraine to call 911. She provided her statement to deputies, and then provided that video footage to the Bexar County Sheriff's Office. But what is most important about her testimony? That when she reviewed that video surveillance herself, she recognized this defendant. She didn't recognize Adis Hernandez Rivas. She recognized Marco Moreno Vasquez. And she told you all that in the weeks leading up to the shooting, Marco Moreno Vasquez, not Adis Hernandez Rivas, this defendant, went to her home and asked for Cubano. And why is that important? Because if you look at the defendant's statement in State Exhibit 217, he tells you he has absolutely no idea who Duniel is. Okay? And Mr. Garcia cannot have it both ways. Okay? He cannot ask you to listen to some parts of the statement and disregard other parts. Because if you look at the charge and the statement that was taken by the defendant, okay, it was a custodial interrogation. Nobody is disputing that. But when you do look at State Exhibit 217, you are going to see that the officers read the defendant his rights in accordance with the law.
And he asked the defendant, can we talk? The defendant states yes. Mr. Garcia submits to you all that the defendant's responses of don't count as yes. But I urge you all to look at the further parts of the interview when he uses the word multiple times to indicate yes. And so if you look in the charge, what the charge says is, if you believe that that statement was taken in violation of the laws, then you shall not consider any part of that statement. And so Mr. Garcia cannot have it both ways, okay? But I submit to you that the statement was taken in accordance with the law. But let's get back to Ms. Zubieta's testimony, okay? She also testified that she knew the defendant, Marco Moreno Vasquez, to own a white truck. Why is that important? Mr. Garcia started making a big deal. Are you sure it was white? Are you sure it was white? And then when we look at Fernando Luna, Deputy Fernando Luna's body-worn camera, what do we see? In addition to the suspect vehicle that was used in the murder, we see that white Dodge Ram. She also testified that officers with the Bexar County Sheriff's Office made contact with her again days after the murder, and that was confirmed by Detective Waits that they went back out there on February 22nd of 2023. That is the day that they collected that projectile that was found in her son's bedroom closet. And she testified that her home did not have bullet hole defects prior to Danielle's murder. Then we hear from Cynthia Cortez, okay, and she lives at 6928 Oldham Drive, and that's about a minute up from the 7718 Winsford location, and it's closer to the Montgomery side, to the exit of Camelot 2. And her home was equipped with cameras, and she provided that footage to the sheriff's office. And then we have the pole cam, that screenshot. That pole cam was situated right there on the corner of Winsford and Montgomery Drive, and that was the only entrance and exit to Camelot 2. And that plate led to the next witness, Juan Carlos Ortega, okay, who was a registered owner of the Chevy. However, you heard from him, and he testified to you that he sold that motor vehicle to Marco Antonio Moreno Vasquez, that defendant, not Adis Hernandez Rivas. And then he also provided the address of 74 Kimberly Lane that lines up to this defendant, and then that phone number 210-574-2898.
She's really fast with those numbers.
Then here is when the Atascosa Sheriff's Office gets involved. All right, they go out to that location, and what do they find? When they're conducting surveillance at 74 Kimberly Lane, they observe their suspect vehicle with a board covering the license plate. All of these facts and circumstances that Mr. Garcia tells you, that would be tampering with evidence, and that's not a charge before you. And while it's not a charge that you can find him guilty of here today, all of those facts and circumstances go to whether he's guilty or not, and it goes to whether he was a party and whether he aided Adis Hernandez Rivas. And I submit to you that the answer to that is yes. Then you heard from Deputy J.D. Ruiz, okay, on February 23rd of 2023, he conducts that traffic stop on Ogden Road, and he pulled that Nissan Pathfinder over and identified the persons and the motor vehicle. And so who was the driver? Eunice Lugo Davila, okay, and that is who, it kind of lines up with what Roxana said about her godmother and that she knew her by the last name of Lugo. Then the front passenger was Adis Hernandez Rivas, and in the back seat was the defendant and Ramona Martinez, his wife. Then you heard from Deputy Luna. So he's the one, he also conducts surveillance. He observes that motor vehicle with the board covering up the license plate. He observed the Nissan Pathfinder arrive there at 74 Kimberly Lane, with Eunice Lugo being the driver. And he observes the defendant, Ramona and Adis, enter that Nissan Pathfinder. Now he makes a scene of the traffic stop, and then he receives that search warrant and executes the search warrant. And what does he find in the defendant's fridge?
What?
Not Adis Hernandez Rivas' fridge, the defendant's. State's Exhibit 211A. Okay, and Roxana told you all that her father provided this firearm to her mother and that it was hidden in that fridge by the defendant and his wife, not by Adis. And then the other thing is that while the sheriff's office was conducting the search of 74 Kimberly Lane, there were multiple shell casings in the backyard, and those were collected and entered into evidence as State's Exhibit 215, okay? Then you hear from CSI Christina Ibarra. She makes a scene. She's the one who sees all this physical evidence, State's Exhibits 211, 212, and 215, right? And then you heard from David Pendleton, right? And he testified to you all that he received State's Exhibit 65, which were the shell casings that were collected by CSI Anderson, and that these shell casings
were fired by this firearm. And then what else does he tell you? That he received State's Exhibits 215 in his lab. And when he did the comparison, it came back to State's Exhibits 211A. He also informed y'all that revolvers do not eject shell casings. And that is important because State's Exhibit 212, when you look at the photos, State's Exhibit 212A is this revolver that was found in the defendant's master bedroom. Then you heard from Adis Hernandez Rivas, and he had many things to say, right? He said that he had only been in the US for about a month. This is corroborated by 3 hours into the interview when the defendant finally starts to give a self-serving version of what happened. He admits to that. He says, I've only known him for about a month. Adis told you that the defendant is the one that solicited him when Adis was downtown looking for work, and that the defendant provided him with work. And what was that work? Tending to the horses on the properties, which there are multiple pictures of that were entered into evidence, and also uprooting cactuses and things of that nature. But Mr. Garcia then asked Adis, well, did you receive payment for this? And what was Adis's answer? No, because I was being provided with food and shelter. And so if you look at the dynamic that Adis had with the defendant, okay, the defendant is in a greater, more powerful position over Adis. Adis told you that they left from 74 Kimberly Lane to go to the murder location. He testified that Adis and the defendant both possessed firearms at this time, and that they both exited the motor vehicle. Adis stated that he heard the defendant arguing with Duniel about this monetary debt, and he observed the defendant shoot Duniel, and Adis admitted to you all that he did discharge his firearm as well. Now, you've already been explained the accomplice witness rule. I'm just going to breeze over it. But if you believe Adis's testimony and you believe that what he is saying shows that the defendant is guilty, then you can believe it as long as there's other evidence to support what he's saying. And I submit to you all that the testimony of Masalud Zubieta, that video at 7718 Winsford Drive, and the testimony of Roxana Martinez all corroborate what Adis had to say. And now let's turn to Roxana's testimony. What did she say? Adis lived on the camper at 74 Kimberly Lane, that they all left from 74 Kimberly Lane to the murder location. And Mr. Garcia, what the testimony was, okay, was that they went to Dairy Queen, and then Roxana said that they went back to 74 Kimberly Lane. And when they were back at 74 Kimberly Lane, the only individuals that exited that SUV were the defendant and Adis. And when she observed her father coming back out from that main living structure on 74 Kimberly Lane, she observed her father with a firearm nestled in his waistband in his back. That's what she told you all. She testified that Adis obtained his firearm while they were in the car, okay? And she testified, this is a big, big part that Mr. Garcia left out, that her father discharged the firearm at and in the direction of Duniel. That's what she testified to, and that was a question that was elicited by Mr. Garcia. And then she testified, I already went over about the firearm and her father taking it from Adis and giving it to her mother to put it in the fridge and hide it. And then she testified that they fled to Austin.
What was in the fridge?
All that lines up with what Adis said.
You've got to say beans.
Now, let's talk about the interview. I submit to you all that the defendant was read his rights in accordance with the law. But what does the defendant then say? Oh, I don't know who Adis is. Adis never stayed at Kimberly Lane. I don't know anything about that Chevy SUV. That's not me at the murder location and the screenshots that you're showing me, detective, even though you can see my daughter's name, Chanel, tattooed down my arm. Not me.
Did she
he
say
said
what
that he doesn't know
Adis
Danielle.
say?
He had nothing to do with Danielle's death. He had no idea that he died. He stated that he never moved forward into the gate. These are all statements that are eviscerated when you look at the video that was seized from 7718 Winsford Drive. He stated that he doesn't own firearms, yet there's shell casings riddled in his entire backyard. He further stated that the shots that are reported in his neighborhood, oh, those are from a neighbor up the street. And he moved a while ago, even though there's shell casings all in his backyard. And then he stated that they left from and returned to Adis's house, when we know that that's a lie, because Adis and Roxana told you that they both went back to 74 Kimberly Lane. He also told the detective that he had no idea where their murder weapon was while it was sitting in his fridge. Detective Arias
in the beans
gave this defendant every opportunity to tell his truth. And he lied for 3 hours until he's confronted with physical evidence, actually. And then he concocts this story where he has no criminal responsibility. Okay, and then he's confronted with witness statements. Once he knows that his wife, Ramona, has said that that's him in that screenshot, oh, okay, that is me. Then he concocts a version that is not supported by the evidence, where he has no criminal responsibility. That is not the truth. They're asking you to believe that the defendant was so scared. I submit to you there's no physical evidence to support that. But look at the defendant's body language on the video from 7718 Winsford Drive. Does that appear to be somebody that's in fear to you all? When he's kicking the gate open, when he's shaking his hand like that at Dunielle and sitting there with his arms crossed, that's not an individual that is in fear. That is an individual who put greed before humanity. That's an individual that went to that location to collect on his debt, and he knowingly engaged in behavior that caused the death of Dunielle.
5 minutes.
Thank you. The story that they're telling you all is not supported by any of the evidence that has been submitted to you all. And then you heard from Detective Waits. He was the lead investigator, and after reviewing all of the evidence, his conclusion was that the defendant acted in concert with Adis Hernandez Rivas and committed the offense of murder. Then you hear from this defense witness, Lorenzo Calderon. Okay, he's been previously convicted of family violence assault. He's currently in the Bexar County Jail for an aggravated assault with a deadly weapon. And he's currently housed with a defendant. Okay, and he comes in here and he tells y'all, Adis told me that he's guilty of murder. Adis told you all that. Adis took a plea saying as such. He has taken responsibility for his role in Dunielle's death. Adis is not on trial because he has taken responsibility by entering his plea. Now, Lauren already touched on the witnesses and that you determine, but each of you have a duty to deliberate. Only you all can make this decision. And your verdict matters, ladies and gentlemen. It matters for the safety of our community. And it decides when this defendant gets to be out on the street again, when he gets to possess firearms again. And you all took your oath, but I want to turn to the law of parties. We talked about this in jury selection, and I talked to you about it in opening. I said, we are not going to be able to prove beyond a reasonable doubt that the defendant was the shooter. What I did tell you all is that we were going to prove that the defendant was criminally responsible under the law of parties. And what is the law of parties? That a person is criminally responsible for his own conduct, the conduct of another for which he is criminally responsible, or both. And we have met our burden. We have proved that to you all beyond a reasonable doubt, that by his own conduct, by him showing up there with the firearm, by him discharging the firearm at and in the direction of Dunielle, that he is guilty under the law of parties. And you can examine the events before, during, and after. And that goes to the hiding of the vehicle, the covering up of the license plate with the board, the hiding the firearm. All of that goes to this. And the soliciting, encouraging, directing, aiding, or attempting to aid. We talked about this in jury selection. There were multiple examples that even telling someone or cheering them on while they're committing the offense, that counts under the law of parties as soliciting, encouraging. And you heard the testimony of Roxana Martinez. She made it clear to you all that her father fired at or in the direction of Dunielle to scare him. Recall her testimony, because that is what she told you all. And just like Mr. Garcia said, she has no reason to get up there and lie. She told you all. And I believe that we have proved our case beyond a reasonable doubt, and we ask you to find the defendant guilty of the offense of murder and deadly conduct as charged in the indictment.
I'm glad we got to listen to this on high speed. I don't think I can handle her.
All right, ladies and gentlemen.
I think they're going to start deliberating right now. Pretty sure they're deliberating right now. Let's see. We're still. This is real time. We're at real time. We caught up perfect, like exactly. the right time when they finished. So I've got a timer going. Started about a minute ago. That might be the stopwatch time for deliberation. The paper over the mouth is an interpreter. She's trying to block the sound from going into the court microphones. They managed to make it all the way through the closing argument without mentioning beans, which I think I lost a bet on. That was 1.25 speed. And I've got to say, even at 1.25 speed, it is really hard to follow that prosecutor. And part of it is that she uses a lot of she's and he's, and he said, she said, he said, and then there was, and he did, and everyone's he. I need more names. I need more anchors to point me to the, to that, use more pronouns a little bit here. Let's use Let's use like proper names instead. Let's use proper names instead of just she's. Actually, that's a new rule, and the rule is you have to fight for your right to party. But verdicts coming in. Well, I'm sure very soon. Glad we didn't have to watch the jury instructions. We skipped them. It was great. Like to skip them when we can. It sounds a bit like a high school debate team member to me. Mock trial. If the beans fit, you must convict. I need to know more about the beans. That was clearly, they buried the lead, not just the pew-pew. Recovery Addict, son's birthday today. Would take a quick happy birthday, Bubby Blackbird, if you have one. 13. Bubby Blackbird. Happy birthday, Bubby. Bubby Blackbird, have a happy birthday. 13's a great age. I have a child in a similar age, and tell me, what do you want for your birthday? And I can't get it for you, but I'm asking because my child has a birthday coming up, so I want to get them what you want. Maybe that's not the right way to do this. Happy birthday. Thank you very much. Happy birthday. Have a good one. There we go. All right. He's mortified. Why? Why are you mortified? Don't be mortified. You're on TV. Happy birthday. Does the defense lawyer speak Spanish? The defendant was speaking to him. If not, there's no language barrier. The defense lawyer does speak Spanish. Okay, let's go back. Where are we at? I think she's going to start calling cases. Yeah, they're deliberating.
Pamar Simpson.
Yeah, she's just calling cases. She's being
I'll let
efficient
them know
with her
that we're
time.
on standby.
All right, thank you.
Thank you, Judge.
We're on standby.
And
Gaming setup.
how's it going?
Wagger's
All right,
husband's
and
birthday
State,
today.
if
Happy
you can
birthday,
see
husband of Wagger.
On Zamaripa, he's supposed to be pleading in a misdemeanor court.
Oh, he is.
Yes.
Yeah. I just need to write.
It's Brent Dela Paz client.
I know the defendant is here, Judge. I don't know where Brent is.
All right, he's supposed to be in misdemeanor court entering a plea.
Oh.
Zamaripa, have you spoken with your attorney?
I texted him earlier and just went to thank you.
All right, have you been to misdemeanor court yet? All right, just have a seat and wait for him.
You want to step out and get water?
Eric Williams. Eric Donnell Williams. Jacob McCumber.
We might have something else to watch here. Just one second.
Kamar Simpson.
Never you have it. Oh, we'll put it. I got a couple in the queue right now.
Yes.
Charge these.
You're the queue. You were the queue. He was building.
Eric Donnell Williams. Jacob Mike McCumber.
You did?
Yeah.
Did he answer? Jacob Mike McCumber.
So, Josh, if you're here with us, we're going to jump to another court for a second while we wait.
That shows that these are agreements that I followed, and so you've waived your right to appeal. Good luck to you, ma'am.
Thank you.
Judge West is supposed to have a trial that starts today. Might not have the language barrier issue that the previous one had. Still in Texas, in the spaceship, in the Star Trek courtroom.
Eric Segrist.
I'm just not sure when it starts.
I think the intent is to add him to the mental health caseload. I don't know if you want us to do paperwork or anything on that, and also consider a jail sanction.
So plead to the motion and then just.
There's only one count. It was trying to contact her from the jail.
Yeah, and that was
you can't do that
prior to him being on his medication.
Okay.
Those jailed contacts, they record those calls, right? They record everyone's calls. So even if you call on somebody else's PIN, they're going to know.
Good morning. Are you Eric Segrist Jr.?
Yes, Your Honor.
And Mr. Segrist, the best you can, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you, sir. You can put your hand down. Will your client waive the formal reading of the motion?
He does.
So let's just go through that motion. Mr. Segrist, in cause number 25, DCCR 1836, I have a motion to revoke your community supervision. Shows that you were placed on probation May 18th of 2026 for burglary of a habitation, and that was a 10-year sentence that was probated for 10 years. Is that correct?
I thought it was probation for 5 years.
Shows 10.
Well, it was 10.
It was 10.
It was 10?
Yes.
I thought it was 5.
Okay.
Maybe there's your problem.
So it looks like it was for 10. And then it alleges that you violated your probation. The only count is count 1. It shows that you violated the conditions of your probation by attempting to contact the victim of the offense, Perla Munoz, through the smart communication messaging system at our jail, May 26th of 2026. And is that true or not true?
It's true, Your Honor.
Did you enter your plea of true to count 1 freely and voluntarily? Is there another?
He's right, Judge.
Is it 5?
Rated for 5.
Oh,
okay.
10 for 5.
Okay. Well,
I had to double check it 2 places, and it's 10 over 5.
Okay. Thank you. Well, thank you for bringing that up. Does the state wish to amend that motion?
Yes, Judge.
Does any objection to that amendment?
Line put the second in and like 5.
Yeah, that's easier said than done on a computer.
Like, go paperless, it's all going to be easier and better.
Yep. It's also like the tiniest writing ever.
Hold on.
Okay. So 10-year sentence that was probated for 5 years. And did you enter your plea of true to count 1 freely and voluntarily?
Yes, Your Honor.
And did you plead true to that count because it's actually true?
Yes, Your Honor.
Yes, Judge. He's just started on probation. We would ask that the court admonish him that he cannot have any contact with Mr. Munoz, and that we will we offer to keep him on probation, make sure he's on the mental health caseload, stays on his medication, and has no contact whatsoever.
So, Mr. Segrist, I have a feeling we probably talked about this at sentencing, that you weren't supposed to have any contact or communication with her. And 8 days after you contacted her, or at least tried to, you are going to end up in prison if you do it again. We will not be here with anybody saying, let's give them medication, let's help them, let's put them in programs. I'm not going to hear it. If you try to contact or communicate with her in any way, you're looking at minimum 2 years up to 20 years in prison. And I'm going to take it very seriously. I can tell you that. Do you understand?
Absolutely.
So whatever the relationship was, it's done.
Yes, ma'am.
And there's no reason for you to ever talk to or communicate with her again. If you do, you'll go to prison. It's that simple.
Yes.
Okay. So I'm going to find that you entered your plea of true to count 1 freely and voluntarily, find that count true, find sufficient evidence to revoke your probation. I'm not going to do that. I'm going to continue you on probation. Again, same condition, not to have any contact or communication. Any issues, you'll be on the mental health caseload if you need any help with whatever it is. Probation's there to help you do that, okay? Yes.
I was wanting to ask you, if like I could have any access to like a mental hospital or prior release, like after I get released.
Talk to probation about that as soon as you're released,
Yes.
because they have options. And if there's something that they can find for you that's inpatient, it's hard to find some inpatient. There's outpatient stuff that you can do. You need to, but there might be something that they can do. You need to talk to them about that immediately. Okay.
Probation officer.
Yes.
Okay.
As soon as you get out and you're released from custody, go straight to probation, make that appointment, talk to them, explain that you feel like you need some help up front, so that you can be successful later. And I'm sure they'll do everything they can to do that.
Yes.
Okay. Thank you.
you.
Go back with the bailiff. And Jody, if you'll just make a note to let his probation officer know that.
Officer is not officer.
Okay.
So,
That what he's asking for is, thank you.
Judge, could you pronounce the 45-day jail sanction in this case?
Oh, you didn't say that out loud when he was standing there. Y'all might have said ahead of time.
Yeah, we said it ahead of time. We said it was a 45-day jail sanction.
With credit for any time?
Credit.
So there will also be.
He's still got another 2 or 3 weeks to get to serve.
Right. Yep.
there you go. Big judge.
Yeah, so Mr. Seacrest, it was also part of that agreement or recommendation that you serve as 45-day jail sanction as a part of that for you violating the probation. So I am going to order the 45-day jail sanction. I think you have some time left on that. You can have probation. If you can have them maybe go out there while he's there so that as soon as he gets out, maybe there's something in place. That would be great. Thank you. All right, you can go back with the bailiff.
Mouse.
Brad Thibodeau. Excuse me.
Brad Thibodeau.
Okay. Come on up. Good morning. Are you Brad Thomas Thibodeau?
Yes.
And will your client waive the formal reading of the indictment?
He does, yeah.
Mr. Thibodeau, in cause number 25 DCCR 0542, you're charged with the state jail felony offense of criminal mischief, impersonating a public service. Is it impersonating or impeding? Hold on. Impeding, sorry. Causing impairment or interruption of public communications. And that's from March 18th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I'm sorry. And I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes.
Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney's office, you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. There would also be restitution in the amount of $1,848. Is that your understanding?
1,480.
84.
1,484.
Y'all wrote 1848. What's the amount?
All right. 1,484.
Okay. $1,484. Is that your understanding?
Yes.
Speak up, please.
Yes, sir.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
State tenders number one.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Thibodeau is not competent?
No, Judge.
What is the state's position with regard to waiving pre-sentence?
We would agree, Judge. He has a 1999 delivery of controlled substance. He received 10 deferred on that. I don't have any indication that he did not successfully complete it, unless he does. And in 2016, he had 20 days on a criminal trespass. With the restitution determined, I have an address for the Windstream Communication Company on 2nd Street in Winnie. It's send it directly there, so I don't have a problem if you don't waive.
All right, so I'm going to waive the pre-sentence report, Mr. Thibodeau, and find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 5 years. You're ordered to pay the fine of $500 as well as restitution in the amount of $1,484, and to follow all of the other rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have a felony conviction on your record. And at the end of the probation, if you successfully complete it, the case will be dismissed. You'll never have the felony conviction. The other side of that is if you violate any condition of probation, you could be brought back into court, found guilty of the offense, and sent to the state jail for anywhere in the range of punishment, which is between 6 months and up to 2 years. Do you understand? It's very important that that restitution get paid from the beginning. A lot of people think, well, I've got 5 years, I'll pay it later. I want you to make payments towards that restitution immediately. Even if it's a little bit every month, get it paid off, okay?
Yes, ma'am.
All right, thank you. Good luck to you, sir.
Yes.
That's the trial court certification. That shows that this was an agreement that I followed, so you waived your right to appeal. All right, good luck to you, sir. Hakeem Manuel Thomas.
Thomas.
What's the temp on in here?
It's set at 65, 69.
Yeah. Good morning, sir. Are you
Good morning.
Hakeem Thomas?
Yes.
And this is 25 DCCR 0843. Mr. Thomas is charged with aggravated robbery. His case is set for trial to begin with jury selection next Monday. And what is the announcement?
Well, Judge, as far as the defense side, we're not ready to proceed at this time. There's some supplemental discovery I've been made aware of, that we're looking to get copies of. I guess as soon as I'm
More
able
body
to
cam.
get that, then I'll be able to assess it and go over with my client, and so we can prepare from there. But we're still
What's
Two
Body
things,
cam.
Judge, if I may.
Mhm.
I had a vacation letter in for next week that I submitted in December.
Oh, okay.
I think maybe this one just accidentally tagged along with.
Well,
posting it.
and sometimes what we'll do is leave it on a pre-trial, and
Yes.
that way if something gets taken
Yes,
care of.
and it happened to be a good thing in this case, and Mr. Wilkerson's here, he represents the co-defendant. I've been working diligently with my investigators to try to get some rather large supplemental discovery from different agencies, not even in a county, DPS in Chambers County Sheriff's Office, video from there. They have sent all that. I received an email with a lot of that yesterday. There's also some things in Fort Bend with respect to older offenses. There's a continuous offense at Port Arthur that goes along with this. So I would prefer to try Mr. Wilkerson's client first. It is set on August 17th. I'll make sure both counsel has that discovery by this week, as soon as I get it all downloaded and get it to them in the appropriate format. But that's kind of where I am.
So everybody should have all of it this week.
Everything that's come in. Yes.
Okay. All right, so let's do this. I'm just going to reset Mr. Thomas a normal reset on the trial docket. That gives, since you're on vacation, gives you plenty of time. And then Mr. Wilkerson's, obviously we'll deal with that in about 3 or 4 weeks, which hopefully will give you plenty of time, Mr. Wilkerson, to go over everything, and we'll see where we are on that case. All right, you can go back with the bailiff, sir. No, on a Keep it on the trial. Stacy Tyler.
Mrs. R.A. and I are deciding how to do a summer science class thing again, like we taught before, for our kids and some neighbor kids. And I think I'm going to be sponsoring it.
Are you sending all those dismissals on Reyes?
It's my judge. I was told they've already been done.
Why are they on the document? Usually they don't show up if I've already signed it. Okay. Okay.
Bless you.
Bless you. Good morning. Are you Stacy Tyler? Good morning. And will your client waive the formal reading of the indictment?
She does, sure.
Ms. Tyler, in cause number 26, DCCR 0800, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from March 30th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with?
I think we've got.
I have here on the tablet some
possession.
documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a cap of 15 years in prison, which means if we go forward, you'll be leaving your punishment up to me. I can sentence you to 15 years. I can give you less. It'll all depend on the information that's brought to me at a sentencing hearing. You have an absolute right to have a jury come in and decide 2 things. The first would be to decide if you're guilty or not, and then you could leave your punishment up to them if they found you guilty. If we go forward this way, you're waiving that, and is that what you want to do? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Tyler is not competent?
No objection.
Right, ma'am. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so we can get a pre-sentence report done. And then we'll come back later for that. Anything that you think is important for me to know, get that information to Mr. Lewis and he'll present it to me on your behalf when we come back. All right? You can go back with the bailiff. Jim Meldred, Willridge. Yeah. What do we do? Where are we on this? Yes,
The James County case has finally been assigned to the prosecutor yesterday.
Oh, good.
So I was able to talk to them. They wanted some time to get with the state here to
Okay.
get some feedback.
So just a normal recess?
Normal reset.
And I did send that discovery to you,
Yeah.
right? Or not via the normal channels,
Yeah.
but just through an email.
Okay, good. All right, you're Jim Eldrin Willridge. And so, Mr. Willridge, what we're going to do, it sounds like the case in Chambers County has finally
one
been
second, we're gonna switch
assigned
courts.
and they're getting some information on that. So what I'm
All
going
right,
to do
what's
is
happening on
reset your
this?
cases here.
Judge, we have, I guess, a tentative approval from ADA Rick Pena for my client to go to felony mental health court. And so we'd like to receive a referral to that today, please.
She can begin the application process for them.
All right. Norma, do a referral to mental health court. Yes, sir. And recall this in 30 days. All right. Once you sign the reset form, you excuse.
Thank you, Judge.
You're welcome. And counsel, make sure your client is med compliant because they will not be accepted if they're not.
Okay, Judge. Thank you.
You're welcome.
So
All
it
right,
looked
who's
like they were
next?
going to do something interesting.
This is
And they
Catherine on
didn't.
page 4. On page 6, 4 down.
Catchings.
We're going to go back to Judge West. Which they look like they're getting set up for something. At least some lawyers are getting set at the tables. Spectators coming in. Might be getting ready to get started here. to track my pantyhose, see when they arrive. Let's see. So this idea came to me this morning. Recovery Addict can recover addicts sponsor. Can recovering addicts sponsor? What? Donna, say that again. I think spell check fixed it so that we don't understand what you said. The idea we've got for science are, when you're homeschooling, the big challenge of homeschooling is social, right? We're good on the content, the lesson, the material. That's great. We're up to speed on that. But the social is what you sort of lack a little bit, because the class is rather small and it's the same people, who live in the house. So we're trying to do I've taught summer science classes before, where we erected a big tent in the front yard, and we would do a couple hours of science classes where we're doing burning lasers and explosions. I made hydrogen using a chemical process, captured it in balloons and mixed it with oxygen and detonated it. It was a lot of fun. Can we help sponsor the science project? I would never say no to that. But the idea is we want to do something again where my kids can hang out, and we would hey, this Saturday we're doing a science experiment. We're doing a science day at the park, and then invite local homeschoolers that we know, as well as some friends that the kids have that are public schooled. So it can be for anybody, but it's a fun time, and it's not like, hey, now do your assignment type thing. We're not learning how to spell sciencey words, but everyone might go home with a glider, or with different types of frisbees and aerobees, as we're learning about flight paths and how things fly, and get some range finders, do some tests, and see how we can get something to go the furthest from one point to a second one. Some catapults, just the basics. We'll do some stuff. I guess you can make oobleck dance. I've never done that one. I've always done just salt, but you can project sound underneath a surface where there's salt on it, and by changing the pitch, the tone that's being generated, and the volume, the salt will dance in different shapes and different. I guess oobleck does the same thing. Donna, thank you very much. Appreciate it. It's going to be a lot of fun. We'll get it going. Paper airplane contest, protected egg drop containers. The problem with the protected egg, we just don't have anything that's high enough to drop it off of. Like the parks that are available for us to do this at are flat. Like, unless I'm climbing a tree, which I don't recommend, and the tree doesn't recommend for me. Hated when people asked about socialization when I homeschooled. Yeah. Oh, I've got a poll going. I need to end the poll. Sorry. End poll. Okay, the question was, has the state proved the case against Marco? Yes, 49%. Need more beans came in at 36%, and no at 15%. So if you combine the yes and the need more beans, then we're about 85% believing that the state proved the case. I think I want to do a flight class. Now, here are my ideas. Aerobees, frisbees, discs, flying discs, all the things you can throw, as well as gliders, so non-powered airplanes. So foam gliders, paper airplanes, balsa wood, and maybe some of the higher-end gliders as well that you can throw. So if we assemble all those, and then we get a fog machine we can use as a wind tunnel, so that we can show how the air flies over something, and how the like by the fog, how it where it provides the lift. That would be good. Get a range finder so we can have the kids throw something, somebody go out there and measure, and we'll measure how far away they are. So like with golf, then we can keep score and see who wins. No fiberglass. I'm doing so much better. There's only a tiny bit of fiberglass left. I probably won't even need the pantyhose. Rocks. We don't own rocks. Rocks don't exist in the part of the country I'm in. You get sand and shells. That's it. We're basically built on a beach. Did he give the labor? No. I'm waiting. I'm waiting till he leaves, and then I'm going to give the ladder back. For dinner order, scallops and risotto, please. Thank you. Could do field trips. I think we'd like to do field trips, but they get really expensive. And I'd like, I mean, last time I charged for the class, and it made it cost prohibitive for some people because we were doing some expensive stuff with expensive experiments and chemicals and lasers and motors and mirrors and everything. But I'd like it to be anyone can come and participate. You just have to show up. So we'll keep the cost down. So the field trip part's going to be down. Boomerangs. Boomerangs are a great idea unless you know how to throw them, and then they're a terrible idea because they come back at you. Rocks are everywhere in the Black Hills. I'll send you some. You laugh. I laugh. Fran, I want so badly to go back to the Weber River in Weber County, Utah, and just find more stones from the bottom of the river. I miss that. I mean, I've got a couple that I've sawed open, you know, like agate style stones that were from there, but I want more. Let's see. Triangulation, you can figure out the contours of the park. That's advanced for the group that we've got, age group. I think the upper end is going to be about 13. Geocaching, that's a fun one. It's not the homeschools can't be perfectly socialized, just that it has to be intentionally worked in. I would say, if anything,
all right, sir, Bradford Josie?
Judge, I was talking.
Bradford, sorry.
You had it right. Sorry.
Bradford Josie.
Yes, right.
And Mr. Josie was previously in court in cause number 25 DCCR 1062. He's on probation.
Yes, ma'am.
For burglary of a building.
Ooh.
And entered pleas of true to counts 3, 4, 5, 6, 7, 8, and 9 in a motion to revoke that probation. I've received an updated
He only missed
report from probation. Have you both had an opportunity to review that report?
Yes, Your Honor. And just for the report, since this report was completed, this morning, Mr. Josie disposed of the allegations regarding allegations 1 and 2, and is changing his plea to true for those.
Let me get that pulled up and we can go over it.
So he missed 1 and 2, but they disposed of those, but he got all the rest. Anyway, I was saying my kids, if anything, socially
I think it'll be easier.
may come across as being more advanced because they're very comfortable holding conversations with individuals that are older and more mature than them.
There's no agreement still. It's still unagreed. Is that correct?
Yeah, sure.
So, Mr. Josie, best you can, raise your right hand. Please, sir, do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. So, Mr. Josie, in that motion to revoke your community supervision that we went through before, it looks like the punishment then was a 2-year sentence that was probated for 5 years. And with regard to counts 1 and 2, count 1 alleges that you committed the offense of evading arrest, a Class A misdemeanor, February 22nd of 2026. And is that true or not true?
True.
Count 2 alleges that you committed the offense of burglary of a vehicle, a Class A misdemeanor, March 9th of 2026. And is that true or not true?
True.
All right. Did you enter your place of true now to counts 1 and 2 freely and voluntarily?
Yes, Your Honor, I did.
And because they're actually true?
Yes, Your Honor.
All right. So I'm going to find then all of the counts 1 through 9 that you entered your pleas of true freely and voluntarily. Find those counts true. Mr. Wilkerson, or do you have any witnesses? Anybody have witnesses with regard to before punishment?
Statements.
Just, yes, we have.
You may call your witness.
Defendant first, call Bradford Josie.
Go ahead.
Mr. Josie, when you were released in October 2025, what was your situation when you were released from custody to begin probation?
I was homeless and I was working towards sustaining a large responsibility of being a community liaison for Councilman Felshaw. I was working in ministry at One City Church and I didn't have a place to stay. And I was spread way too thin to have all my support in Houston. I'm from Houston.
Now,
Community
obviously,
liaison?
anytime you have a case like this, right, where somebody's released on probation, given an opportunity, and immediately doesn't show up, doesn't do anything, the question is always, well, why should I give you another chance? What do you propose to the court will be different if you are allowed to be reinstated with some sort of sanction, some sort of treatment program?
Mhm. The lengths that I've gone to acquire solid accountability and solid backing that hold the integral witness of the community of Beaumont. Most of my accountability had been, I would say, sort of ineffective because it was out of reach. It was in Houston, and so what I've done is what I've been able to accomplish.
How old are you?
I'm 36.
Okay. All of this, my accountability and you're 36.
Yes.
You're not 18. So I need to hear a little more about
what you did.
The answer to Mr. Wilkerson's question.
So specifically, if the court were to reinstate you with some sort of sanctions, what is your plan upon discharge?
My plan upon discharge is to attend Unity Treatment Center and through Spindletop, follow up with a primary care doctor that could have me on the right medications. I was in Harris Health in Houston, and it was hard going back and forth from Beaumont to Houston to keep up my prescriptions, and that's how I went into that lapse. So I would get associated with Unity Treatment Center under Ron Harris as the director, and I would reassume my role in sobriety.
Your plan then would be to transition from being incarcerated directly into an inpatient treatment facility.
Most definitely.
And through Unity, you would have a case manager then who would coordinate with Spindletop.
Most definitely.
Now, obviously, your mother will talk about what she's done, but is it your understanding that some preparation and groundwork has been laid toward those goals of getting both mental health treatment and drug treatment?
Extensive.
In terms of, I mean, when you got out the first time, you fell off the wagon.
I sure did.
And in terms of discharge from incarceration, do you think it would be beneficial for some sort of coordination of care? Obviously, mental health caseload, but some sort of discharge from where you go directly from county jail to Unity?
I'm in agreement, and also I do seek to involve myself with further outpatient care that I would usually seek. I think that's one of the missing things that I've never implemented was a follow-up. I've never done a solid follow-up with anything that I've done as far as treatment. And so I would look for the outpatient program of.
I think he's trying to use the keywords,
which would be Spindletop's outpatient program.
And then, you have any objections to participating in the Jefferson County Drug Interdiction or Intervention Program?
I have no objections for that.
You understand that would add yet another layer of accountability.
Yes, I'm aware.
You also understand that if the court were to give you an opportunity and to reinstate your probation, despite these violations, that it would be a last opportunity.
Yes, I'm aware.
And So you've spent 138 days in custody now, is that correct?
Yes, sir.
All right. And instead of saying, Judge, just give me a short sentence and be done with me, you're asking this court to continue your supervision with modified terms.
Yes, that is what I'm asking for.
And you understand that, of course, that your probation will still run for 5 years and you'll be under all of these restrictions and conditions for the entirety of that time.
I am aware. Yes, sir.
Do you think that that plan has a better chance of keeping you accountable than just going to state jail and being discharged from state jail?
Most definitely. I waited out, and I actually sought wise counsel outside of my own planning. And I don't have a background of recommending treatment to people, so I sought the insight of people who do this on a weekly basis, people who go into prisons to deliver a message of sobriety, and they all decided sort of as like a small panel that this is the best thing for me to do.
As far as medication and mental health treatment is concerned, are you currently receiving treatment while in the custody of Jefferson County Sheriff's Department?
Yes, I am.
Okay. And is your medication working?
They just changed it. It started working effectively, I would say about a month ago, before I became a full-time trustee.
Pass the witness, Your Honor.
Mr. Smith?
So, Mr. Josie, this consortium of experts determined that Unity was the best place for you. If the judge were to consider placing you into some kind of treatment, you told probation that you would not do substance abuse felony punishment facility. Is that correct?
I'm sorry, would you please
safety?
You don't want to do safety. You told probation you would not do safety.
I don't want to do safety.
Okay. And you were not sure about ISF?
I'm not indifferent towards it. I would oblige.
Well, that's very gracious of you to accept something like that.
I would oblige.
That's really saying a lot, that you would allow the judge to put you in something like that. You understand you don't have the choice here? You don't get to decide where you go, that the judge does? And this magi that you've consulted, who says that Unity is the best program, you expect everybody here, and the judge especially, to agree with that just because you say it. That's fairly arrogant, isn't it?
Well, actually, I do appreciate and look forward to everyone's honorable opinion. Like I said, I don't have much experience giving any recommendation to anybody outside of sponsoring people for AA.
No further questions.
Mr. Wilkerson?
Just want to follow up. Just to be clear, Mr. Josie, obviously, whatever the court does, you're going to comply with the order.
Yes, sir.
You did previously indicate that you thought that the substance abuse track of ISF would be more appropriate for you. Do you understand that the court certainly, if it is to consider, if the court is even considering reinstatement, that the court has, of course, the option of safety. There are 2 different tracks at ISF. You're aware of all of this, correct?
Yes, I'm aware.
All right. And you're asking the court to reinstate you, to give you an opportunity to continue supervision and to receive both the drug treatment and mental health treatment that you require?
Yes, I do.
Okay. You also have restitution in this case, is that correct?
Yes, I do.
All right. Pass the witness.
Anything else, Mr. Smith?
No, Judge.
So, and I'll allow you to call his mom, but I am going to just tell you now that if I continue Mr. Josie on probation, it will not be at a place that's not a lockdown facility. So, the Unity House might have been something that was an opportunity at one point, but Mr. Josie he never showed up. He never did anything, and he committed 2 new offenses, has admitted to serious substance abuse issues with some mental health diagnosis as well. So ideally, for his benefit, special needs safety is the best place because it takes care of both at the same time. And so if I'm going to consider anything, if you want to call his mom, but to go through, and I appreciate if she's done that to try to get him in a outpatient or a place that's not locked down, but that's not going to be where I am.
Right, and I understand that, Judge. And so, one of the things that we have talked about, and his mother is kind of giving her kind of last ditch effort too. She's getting older, but one of the things that we've discussed is whatever sanction, if the court were to consider reinstatement, whatever sanction the court imposed upon his release from that, to then be released into the program at Unity so he can have that 30 days plus the access to the case manager to work with Spindletop and
I'm not opposed to any of that. The way it'll work is probation will make that ultimate determination on what the aftercare is and where the best place is. If it's through Spindletop, if it's through Unity, or if it's through something else, I'm going to let them make that decision. So it's not, I'm not going to say right now because I don't know how he'll do and say, okay, for sure when he gets out, it's one thing or the other. It's going to be whatever the experts say it should be. So I'm gonna rely on them for that. All right.
I do think it's notable, Judge, and I wanted to call Miss Josie because she has put a lot of effort into this, but I think she hears the court as well, and I don't think that's going to be necessary. I do think
and I see her in the court, and I appreciate you being here and everything you've done, and I hope you appreciate where I'm coming from on this with regard to some more intensive treatment for a longer period of time.
I do think that it is worth noting that despite the fact that at this point, having already 135 days, and if he could get a short, safe peace sentence, the possibility of him being out in 6 months and being done versus going to treatment, I think it says something, Judge, that he is asking for that opportunity.
Sure. No, I appreciate that as well. And Mr. Josie, I mean, Mr. Wilkerson is right. You could take some time and probably be done at some point around the same time, probably a little later if I gave the whole 2 years. But if you really want to do better in your life and not continue to make the same mistakes that you've been making, then I would hope that you would take this opportunity and take advantage of it and be successful on the probation and not be back in court on another case. Because if you just do your time, you're not going to get, I think you need some inpatient lockdown type treatment. All right. Anything else then?
Nothing.
Probation's here. Yes, ma'am.
Right. He just has those 2 new misdemeanors, Judge, that would have to be resolved.
They took care of them already. Thank you,
Yes,
Ms. Kane.
Yes, ma'am.
All right. So what I'm going to do then, Mr. Josie, and I appreciate that you came in and took it, responsibility for the 2 new cases as well, and that you've worked those out. That makes a difference for me as well. So I am going to find that those new pleas of true to 1 and 2 were made freely and voluntarily. Find all of the counts true, 1 through 9. Find sufficient evidence to revoke your probation. I'm not going to do that. I'm going to continue you on probation. I'm going to order as a condition of your probation that you enter and successfully complete the safety program. If the special needs safety is what's warranted, I'll let probation go through that with all of the assessments, and then that's where you would go. When you're out, you'll go through whatever recommended aftercare treatment there is. Anything you want to do in addition to what they order is great, but they'll go through with you what the appropriate thing would be, and what's also acceptable through probation and things like that. I do want to make sure you understand this opportunity. The first opportunity you got to be on probation was a big opportunity. Getting another one is, it's not going to happen again. All right, so you need to take advantage of all of this, because if you violate again, you'll be looking at that 2-year sentence that you've already agreed to. Do you understand?
I understand.
All right, I'm handing you the trial court certification. It does show there was no agreement. You have some rights to appeal. You can talk to Mr. Wilkerson about that. Good luck to you, sir. Thank you all for being here.
Thank you, Your Honor.
Thank you, Mr. Wilkerson. I just wrote on it.
Wow. So he violated 3, 4, 5, 6, 7, 8, and 9 of his probation, and he gets another shot. And he comes in and he says, hey, I'm not going to do Safe P, but I do like this unity thing. I talked to some mystic. Was it Magi? Mystic? The smart dude. And he says, that's where I should be. Prosecutor said, I'll have none of that. That's not what we're going to do. And so it's Safe P it is. All right. Thank you, Your Honor. Yes, running with the hatchet is the only way to go. Let's see. I think you spelled should have wrong. At what point does somebody not want to be free if they break 80% of the conditions of their release? Yeah, I just don't see that ending well for him. All right. My daughter's super excited about the science stuff.
Court would find violation of condition number 4 true. Is there a proposed agreement?
There is not, Judge. We're pleading open to the court.
Ooh,
all right, State, what are you requesting?
Judge, because the defendant has numerous violations and has basically been absent from probation for about a year and a half, Judge, we'd ask that you revoke the defendant and sentence him to the maximum of 10 years.
All right. Defense, what are you requesting?
Your Honor, I'd like to call my client.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Jacob Montreal Harris.
All right, you may proceed.
Thank you, Your Honor. Mr. Harris, what are you asking the court to do today?
To put me back on probation.
Why do you believe you deserve another shot at probation?
I wouldn't say I made a mistake. I made a bad choice. Making stupid choices. I'm bettering myself. I just want to be there for my kids and be there for myself. Do right.
Part of that time that the court alleged, and you have also pled true, that you were not reporting to probation. Were you actually in custody somewhere?
Yes. Yes.
Okay. Where were you in custody?
In Florida. But
that was sorry, just recently. I can't understand a word you're saying. Are you?
I was in custody in Florida, but that was just recently. Before I was not in custody. I didn't report. I
was in custody before I was in custody.
What was he doing in Florida? Because did he receive permission to go to Florida?
No, ma'am.
What was he arrested for in Florida?
What were you arrested for in Florida?
For
possession.
Charges were dropped, but I was arrested for false identification and I forget the other charge.
Some other crime.
And what proof do you have that the cases were dropped?
I have full proof. They dropped the charges. Charges I was under sitting for like a month and a half. They dropped all the charges and I was extradited over to Berkeley County.
Did you have permission to be in Florida?
No, ma'am.
That's bad.
But you're asking the court to give you another chance at probation, correct?
Even the defense attorney's like,
is there anything else you'd like to tell the court
worse.
as to why you believe you deserve to have another shot at probation?
I just want to say my apologies for wasting your time.
Here's the thing. Nobody is wasting my time. This is what I get paid to do.
Yes, ma'am.
Mm-hmm.
But what I can tell you is this is your third motion to revoke, and each time you're not reporting. So I can tell you, you're not being continued. And then now I discover that you're in Florida. You're not supposed to be in Florida. And when you first had a motion to revoke, it was in 2022, and it was a violation of condition number 4. And I allowed you to transfer to Coppers Cove, Texas, Coppers. Then another motion to revoke was filed in 2024 for not reporting. And at that time, you wanted to transfer to Clayton County, Missouri. I allowed that. And then now we're here and you said, oh, I have children. I want to be there for my children. And then now we're back here for a violation of condition number 4. So the court is going to revoke.
Yes, ma'am. Can I say something?
Sure.
Oh, sure.
I would like to say, both of the time that I was transferred to, where I got my probation transferred, it was not a set home for me. One of the homes in Coppers Cove, I ended up getting to the person that I was staying with. They didn't want me there because of what I was going through. My mom, she stays in Shatter, Nebraska. I have the address. She said she's.
But is she in Florida? Who's in Florida? Why were you in Florida?
I was in Florida because I was going down there for work. I knew a guy. I was working down there. That was my only resource at the time. But
you sure are able to travel from place to place with no resources. Do you see you, Bear County, then you're in Coppers Cove. I don't know what the distance is from here in Coppers Cove, but I believe it's more than 30 minutes. Then from there, you're going to Missouri. Then from there, you're going to Florida. Yeah, I'm granting the motion. I'm going to find you guilty, give you credit for any time served. There's to be no contact with Adam Campos. Court is going to sentence you to 5 years in the prison. There's to be no unsupervised contact with minors and no residing in households with minors. And I'll request the therapeutic community and counsel, if there's some time where he was in custody, he's saying it was a short time, not for the years that he didn't report. Just let the clerks know and they'll give him credit for that. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. All right. Good luck to you.
Thanks.
You're welcome. Who's next?
He ran out of chances.
Mr. Blake on page 4 down.
Okay, we're going to go to Judge Dad.
All right. That's a motion to revoke.
While we wait. Hold, please. Judge Dad is lined up. We're ready.
People against Zooch. Sure.
I don't know what this case is, but People v. Zooch. I'm going to go up in the corner, top corner. I'm moving to the top. Moving up. There we go.
All right.
SF in Texas, thank you for the gift. The high five looks great. I just saw the judge sort of looking, so he's tired, sitting back thinking about this one. So we might have to bail if it's a bad one, but we'll take a quick look and see what's up.
We still have another exam that the attorney hasn't checked in for.
That who hasn't?
The attorney.
What?
What exam is that? Lisa, do we have another exam?
Butler.
Yeah, which one are you looking at?
Butler.
Butler.
Judge, that's the one I was asking about.
Bueller?
I don't have my witnesses present. I tried to call him to see if he could just zoom in just so I can, since I can even move forward on it. I couldn't get a hold of him. I kept saying both failed. I tried about 2 or 3 times.
Are you sure that was Quentin Dox? I think it was somebody besides Quentin.
I'm sure about that. I've seen him on many, many times.
I thought I thought somebody came on one of the cases for him. Do you have the file?
I can grab it.
Please.
Judge, are we recording the docket?
I'm sorry.
Do I
Yeah.
do I need to call him or is he here?
She's checking on the file. Are we sure it's Docs?
Yes.
Yeah, call him. I think. I mean,
The last time we were here, you held a competency and then we moved it to exam.
yeah, please call him. Is it
Okay,
Mr.
I'll call him.
Docs? Yeah. What time was that scheduled?
That's still 10:45.
What is going on with some of these people?
Uh-oh. He's mad before it
Can
even
I see the
starts.
file?
He's complained several times about, back in my day, I didn't have to get called to court by the judge to show up for a hearing. And now here he is babysitting
Call him
lawyers.
up, would you please?
Nice.
What's that?
Sure. I tried multiple times. It just kept saying call failed. No. I don't know if it's the Wi-Fi in the port or what.
Yeah, call him, Lisa. Where's the defendant at?
He's locked up back here.
This is
Judge, he said he's on his, sorry, he said he's on his way. He's at Sibley Road.
I know, but it's scheduled for 10:45. I mean, come on. Jeez. All right, Charles Edward Zuch, 267-702-544.
And good afternoon, Your Honor. Not today. I'm around for people be 8853.
Good morning or good afternoon, Your Honor. Alyssa Segura, the Neighborhood Defender Service, P86432, appearing on behalf of Charles Siege, who stands to my right. Say your name.
Charles Siege. All right, today's the date scheduled for preliminary examination. We have a multiple count felony. Can't see if it's 7. It looks like 7 counts with habitual second. Possession with intent to deliver 50 grams or more, but less than 450 of cocaine. Possession of ammunition by a prohibited person, possession of a firearm by a prohibited person, CCW, felony firearm, 3 counts of felony firearm. Any preliminary matters that you have?
Preliminary matter, Your Honor. This time I am visiting the proposed exhibit number 1, which is going to be certified copy of the register of actions that shows the defendant was sentenced on a crime of assault with intent to rob while armed on December 11, 2008. And I did show this copy to defense counsel as well.
Any objection?
No objection.
People's one is admitted. Sir, you can have a seat.
Okay,
You sure can. And I want her to mark those though, with her initials, and
I can bring it up.
that's okay.
Some courts like it for us to mark them, so I apologize.
That's, who's got?
Phone is that? Mine, sir, Your Honor. Oh, sir, they didn't convert yet. I don't know.
Just was that, yeah.
Detective, your name, please?
Technical, this would take this back.
Good afternoon.
Yeah, that's right.
It is afternoon.
What was your name?
Detective Bro, GROAT.
All right. So we've had that admitted. Any other preliminary matters, Mrs. Farman? Any other preliminary matters, Mr. Guerrero?
Just a mutual order of sequestration, Judge.
All witnesses, with the exception of the officer in charge and the defendant, are to leave the courtroom. I'm not keeping you up, am I, Mr. Such? Why don't you sit up a little?
And Your Honor, there are, for the record, there are 2 individuals in the courtroom. One is Mr. Seach's father, and the other is his girlfriend. Neither were present at the time of this incident. If this were to proceed to trial, I would not intend on calling them as witnesses.
Then
I don't believe the prosecutor would as either, but
Then they can remain in the court.
thank you, Judge.
Judge, I did also want to mention that the officer in charge, who is a student's medical detective, Bro, is also going to be my third witness in this game. In this case.
The 3 witnesses in this case?
That's fine.
Okay. Go ahead. Call your first witness.
Officer Oliver.
Come on up here, officer, please. Raise your right hand. You solemnly swear affirm? You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God.
Yes, I did.
Could you spell your name for my recorder, please?
ILKYLE, Tolliver, TOLLIV.
Thank you. You may proceed.
Thank you, Your Honor. Good afternoon, Officer Oliver.
Oh,
Officer, could you tell us where you're employed?
the Brown South Police Department.
What does he do in Brownstown?
I'm a police officer.
And how long have you been an officer then?
Approximately 9 years.
And were you employed as an officer on March 16, 2025?
I was.
And at some point, did your duty take you out near Sibley Road in I-75?
I did.
Was that in Trenton County, Illinois?
Brownstown.
Oh,
That's-
was that in Trenton or Brownstown? That was the Trenton, over the border?
No, the zip code can sometimes come out as tribe.
Okay, I understand. What's at this area, Sibley Road in I-75?
What's that area?
Yeah, what's in that area? What were you doing in that area?
So that's traffic stop.
Okay, where was the traffic stop at?
on Sibley Road over I-75.
Okay. And then what was the traffic stop for?
It was for the vehicle that was stopped. The initial traffic stop was for the vehicle driving left of center crossing double yellow.
Okay. And, is this where you initially saw the vehicle? Where is it you initially saw the vehicle?
Pulling into the Palace Motel to get a telegraph in Berks County.
Okay, what was it you were doing in the Palace Motel?
I was conducting surveillance of the motel for short stay traffic.
Why were you conducting, surveillance on that hotel?
At the time, I was part of what we call the CSU, Unit Community Support Unit, with a focus on narcotic enforcement.
Okay. And did you observe, you stated that you observed this vehicle previously at this motel?
Prior to the date given?
On the same day, March 16th, 2025, did you see this vehicle?
Yes.
Okay, and you saw it at that motel?
Yes.
What did you see that vehicle doing?
That vehicle pulled in and it stayed for approximately 3 minutes and then left, which we consider short stay traffic, which is indicative to possible narcotics sales and no purchases.
Okay, and then you stated at some point you conducted a traffic stop. How long did it take for you to conduct a traffic stop after seeing it at the motel, the vehicle at the motel?
Approximately 2 to 3 minutes.
And then after you conducted the traffic stop, did the vehicle stop?
Yes.
And did you approach the vehicle?
Yes.
And how many occupants were in the vehicle?
2.
And would you recognize any of the occupants that you saw today?
Yes.
Did you take a look around the courtroom and point out and identify an article code that individual is wearing?
The driver is
Jail
wearing a
jumpsuit.
green shirt and green pants.
Your Honor, this time either under the court witnesses identified Mr. Siege, I believe.
The record should so reflect.
Thank you. And what happened while you were approaching the driver's side?
I made my initial contact to gain identification of the driver, and Officer Walker and Waterworth arrived at my stop.
Okay. Were they called to your stop or did they just arrive?
They arrived as backup secondary officers.
And did you make a call for them?
No.
So after these officers arrived, what do you think else happened?
I gained the driver's license and a verbal identification of the front passenger. While I was checking the driving status of the driver and the identification of the passenger through dispatch, Officer Walker utilized his canine partner for opening the stuff.
Okay, can we provide with any information from Officer Walker?
I was. He advised me that his canine partner.
Judge, out of your side. Judge is not going to do the matter, sir, that it's a technical listener. He's provided with information based on information, conducts an investigation, or does something else based on that.
Judge, so my response would be this, that he can testify to what he did after having a conversation with us.
I'll sustain the objection, strike that portion of the testimony. Rephrase your question.
Thank you, Your Honor. And based on the information you were provided by Officer, is it Walker, what did you do?
Well, I got the female passenger out after Officer Walker secured his canine partner, and then Officer Walker got in the driving problem.
The judge.
And then what happened after that?
Judge is catching up on a little sleep.
Officer Walker observed some narcotics.
Judge, I would object to any observations that Officer Walker made, or ask that he only testify to his observations.
Same.
Did you observe anything personally?
Yeah, I have plain view that I observed. Once I conducted the inventory search, but initially no.
Or what was the inventory search going to be conducted for? Or why were you conducting an inventory search?
We conducted the research because Officer Walker had already placed the driver in custody based on his observations, and I had the female passenger step out. I asked her if she had anything illegal on her person. She said no, but quickly recanted.
Judge, I would object to any statements made by, as hearsay, by the passenger.
And Judge, again, it's not going for the truth of the matter, sir, that she stated no to this, knows having narcotics on her.
Did she make any incriminating statements about the defendant? About Mr. Zuch?
I do not recall.
Okay, I'm gonna overrule. Go ahead and finish your answer.
What is it the passenger did?
She provided me with a small bag of suspected narcotics that she removed from her bra.
Okay. And then, was that individual placed under arrest?
She was immediately placed under arrest at that time.
And you stated you conducted a inventory search?
Yes,
Were you the only officer conducting the search?
the officer wanted her assistant.
Okay, and did you recover anything?
I did. I recovered a large bag of suspected narcotics from the driver's side floorboard that was in a solid case. 2 spoons with narcotic residue on them. We suspected narcotic residue on them. A loaded firearm that was tucked between the driver's seat and the center console.
How did you know the firearm was loaded?
I made it, once I discovered the firearm, I made it safe. I'm making it safe. I ejected the round from the chamber.
Was that firearm placed in evidence?
Yes.
Okay. And you stated that it was found on the driver's side, what was it between?
The driver's seat, center console.
Okay. And, you also stated that you recovered, suspected narcotics from the floorboard. Could you tell us how that was packaged, if you recall, or what it looked like?
The suspected narcotics was a white brick that was placed in the black shopping bag that was also placed in a soft case. The driver's side.
Okay, and what else did you recover from this vehicle?
There was a blue cylinder hanging from the steering column that contained suspected narcotics. There was a baggie in the driver's door mat pocket that contained suspected narcotics. There were shotgun shells in the center console. I recovered several cell phones throughout the vehicle. Also, additional and smaller amounts of suspected narcotics that were in clutch, purse, bag, in the back seat was located. There was also an additional rounds of ammunition found and loaded in the magazine by Officer Walker.
Okay, and was this all the items that you recovered were placed in evidence?
Yes.
Do you recall if you recovered anything else or saw anything else?
There was also items removed from the defendant to the driver's person that was taken from Officer Walker.
Oh, do you recall if any other items were recovered in the vehicle? Or seen in the vehicle?
Off the top of my head, yeah.
Okay, would it refresh your recollection of viewing the report?
Possibly.
Judge had a late night, I think. Robe's a little itchy this morning. Maybe he was
Maybe
carrying
that's
a
why.
ladder.
Please take a look at the report, read it to yourself silently whenever you violate has been watched, please don't have an audience.
Keeping an eye on Judge Boyd. She's still just running her regular docket. We are, I forgot to give you guys the timer. We're an hour and 14 minutes into the deliberation time. And I had a spoon from lunch. Like, oh, there it is.
Mr. Dux, you're late.
Morning, Officer.
Morning, Your Honor. Yeah, says the attorney who's 2 hours late for his own hearing.
Do you remember your question?
Yeah.
Okay, if you recall what else was found in that vehicle?
I also discovered a female's ID and social security card that did not belong to the female passenger.
Okay, and then you stated earlier that you were part of a narcotics team at that point.
It was a community support unit is what we call it with a focus on narcotics enforcement.
How long were you in that, the community, that specific section?
It was only, that unit was only active for approximately 3 months.
Do you have any training experience in narcotics?
I've been to multiple narcotics training courses and classes such as President Snow. And then throughout my 9 years of all road patrol as a police officer, I've come across several narcotic arrests or instances involving suspected narcotics.
Okay. You stated earlier that you found, 2 cell phones, multiple cell phones.
Yes,
And how many cell phones was that you found?
movie score.
Okay. And, do you know who those belong to? There were 2 individuals in the vehicle. Do you know who they belong to?
I assume it belonged to.
Judge, I would object to speculation.
Sustained.
Can't say I assume they belong to.
You've dealt with narcotics before. Do you know what multiple phones that indicated roughly?
Narcotics settings.
Okay, was there anything else found in that vehicle that would indicate this as well?
There was also 2 digital scales that were discovered in the vehicle.
Okay. And then, and following that, did you do anything else in this investigation?
Once all the evidence was collected from the vehicle, the inventory was completed, and the vehicle was removed from the scene by Marcus Towing. I transported all the evidence back to the station where it was cataloged and photographed and put in the evidence. And the detective bureau was notified.
Nothing for this witness. Thank you.
Ross?
Ms. Graham. Officer, you indicated that the first time that you observed this vehicle was in the motel parking lot, is that right?
Pulling into the motel.
Okay. And you indicated that it stayed for 3 minutes.
Approximately.
You indicated, or I guess you did not indicate whether anyone came up to that vehicle, right?
Correct.
I mean, you didn't see anyone leave the vehicle,
Correct.
and you didn't see any hand-to-hand transactions with that vehicle.
Correct.
But you followed that vehicle once it left the location, right?
I did.
Okay. And prior to that, you were not familiar with this vehicle, were you?
I was not.
Or the occupants that were in this vehicle?
I was not.
But you followed it because you suspected that it was involved in some type of narcotics?
Is the judge okay?
When you followed that vehicle, in observing it, you seen that it crossed over a double yellow line. Is that what you indicated?
Yes.
What crossed over the double yellow?
The vehicle.
The whole vehicle?
Partial parking vehicle.
What part of the vehicle?
The driver's side.
The driver's side. So the entire driver's side passed over this yellow line.
Yes. Not the entire vehicle, but the driver's. The word crossed over the double yellow.
Would the tires have had the tires crossed over the double yellow?
Yes, the driver's side tires.
Understood. So both tires, so the front left and the back left crossed over this line. All right, understood. And so you conducted a traffic stop because of this observation, right?
Right.
But you conducted this likely because it was a pretextual stop. Would you agree with that?
Your Honor, I would object to the pretextual stop. I don't think it's argumentative, Judge. I'm asking him the reason behind why he was following.
I think you need to rephrase. I'm gonna sustain the objection. You can rephrase if you want.
Understood. So I guess just to backtrack, you followed it because you were suspicious of this vehicle, right?
Right.
But you didn't observe anything at the motel that would lead you to conduct a traffic stop, correct? That's why you followed the vehicle.
You're gonna have to keep your voice up a little bit, okay?
And so this observation of crossing the double yellow allowed you to conduct a traffic stop, is that right?
Yes.
Understood. Now, you were driving a scout car at that point, is that right?
No.
No, what were you driving?
An unmarked police F1 division.
An unmarked, but you yourself had uniform on, is that right?
I was in plain clothes, but I had my police vest on with bag very, police meter.
Understood. So was your vehicle equipped with a dash camera?
No.
It was not. All right. So you don't have anything to show that this vehicle actually crossed over without vehicle?
No.
When you approached, you indicated the reason as to why you stopped, right?
Yes.
And then the dog sniff happened, correct?
Yes.
And this led to a inventory search for recovery narcotics, correct?
Yes.
And the driver was arrested because of observations not only by you, but Officer Walker, right?
Yes.
But you never wrote a ticket to Mr. Siege for crossing over a yellow line. Would you agree with that?
Right.
And you towed the car, you processed an impound slip for this car, correct?
Slip, I do not recall until about it slip me was on.
You didn't process that then, right?
I don't recall.
Understood. I know for the questions.
Any redirect?
Incidents like this that are involving possible felony charges, we've been advised to hold off on issuing citations until
Judge, I would object to that as hearsay when I was told by someone else. It's not finding something else that someone told them.
Well, Judge, I would also state that he's specifying as to why he did it.
Yeah, I'm gonna overrule the objection.
Officer Teller, you stated it's because of policy or something you told?
yeah, we've been advised by our detective bureau and our supervisors when the cases involving possible felony charges is to hold off on issuing citations until told otherwise by an OIC.
Okay, nothing further this one. Thank you.
Anything else, Mr. Guerra?
I have no follow-up, Judge.
Thank you. You can step down, sir. Call your next witness. See that other file, John.
In custody?
Did somebody move to you?
Yeah, he's all ready to go. I already got Robinson. Robinson's going to zoom in.
Who's this? Who signed that?
I told Robinson about it. He says he's aware that he's taking the zoom in. They'll be on record when he got it.
I don't make sure.
I don't make sure
it's right. Yeah. All right, you can come on right up here, officer. Let me ask you to raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth. So help you God.
I do.
Okay, have a seat, please. You may proceed.
Thank you, Your Honor. Good afternoon, Officer Mulder.
Good.
Brownstown Police Department.
What do you do at the police department?
I'm the canine handler, the road patrol officer.
How long have you been an officer for?
7 years.
How long have you been with K-9?
Since September of 2023.
Were you employed as a K-9 handler on March 16, 2025?
Yes.
Okay. And going through, you stated you're a K-9 handler. What kind of training and experience do you need to become a K-9 handler? Certifications?
Initially, it's a 3-month academy process before the dog is certified, and we have to pass the certification test after that 3-month process before you were certified to use the dog on the road. From there, I attend training 8 hours every Wednesday of the month.
Okay. And are you certified?
Yes.
And who's your partner?
Bane.
And was Bane with you on March 16, 2025?
Yes.
And that's something like that is that in your Sibley Road 975?
Yes.
Okay, is that in the 500 miles an hour?
Right.
Is that going to be County Lane?
Yes.
Okay. And what were you doing in that area?
I was assisting Officer Palabra traffic stops.
Okay. Was it just you and Bane?
Yes.
And you were actually, did you observe the actual officials of the office?
Okay. Yes.
Would you recognize any individuals that you saw today?
Yes.
Could you take a look around the courtroom and point out and identify how we met individual?
The male seated right there in the green
parents, I mean, they were reflected what you said.
Records should still reflect.
Where was this individual when we first encountered him?
On the driver's seat of the vehicle, on the traffic stop.
And you stated that you arrived with your dog Bane, is that correct?
Yes.
And what did you do with Bane?
I conducted an open air sniff of the vehicle at Officer Colliver's request.
You stated Officer Tolliver was present?
Yes.
Do you recall what he was doing when you made the scene?
When I arrived, he was still at the window of the vehicle making his initial contacts with the driver and passenger.
How long did it take for you to arrive at the vehicle? You recall?
Less than 2 minutes.
And you stated that you did an open air sniff?
Yes.
Okay, could you go through how that's kind of done?
I took my cannon partner to the front passenger bumper of the vehicle. From there, we hook him up to a different collar. He knows that when I change his collar, that it's a narcotic collar. I hooked him up to that. I told him to find dope. We ran around the car in counterclockwise direction. And then on the driver's door scene, he scratched and bit at the door, which is a positive indication for narcotic odor. He is an aggressive indication, and he is trained to scratch or bite at odor.
Okay. And you stated he did that at the driver's side of the road?
Yes, the driver's door scene.
Do you know where the passengers in the vehicle still, or were they outside of the vehicle?
They were inside the vehicle.
How many individuals were in the vehicle? 2. Okay. And what did you do after there was an indication?
I placed my cannon partner back in my vehicle, went back up to the defendant's vehicle. Officer Tolliver got the passenger out while I got the defendant's seat right there out of the vehicle. I asked him if I could pat him down for weapons, located a small knife in his right front pocket.
Did Mr. Seach allow you to pat him down?
Yes.
And did you observe anything when Mr. Seach exited the vehicle?
Yes.
What did you observe?
I observed a bag of what I suspected to be a clear plastic bag of white powdery substance in the mat pocket of the driver's door while I was patting down the weapons.
Okay. What did you do with that bag that you observed?
I left it there.
And was there a search on the vehicle?
Yes.
Did you assist in the search?
Yes.
Okay. Who searched the vehicle?
Officer Tolliver.
And did you let Officer Tolliver know about the indication?
Yes.
And did you recover anything personally?
Yes.
What did you recover?
Off the defendant, a clear glass pipe I suspected for smoking narcotics, as well as a rock that I suspected to be crack cocaine, which when I asked the defendant, what is this, he said it was dope. I secured that, and then while assisting in the search of the vehicle, I located a magazine with a magazine for a handgun with 9mm ammunition.
Was Mr. Seach placed under arrest?
Yes.
At what point was he placed under arrest?
When I secured him in handcuffs, after I patted him down for weapons, when I observed what I suspected to be narcotics in the passenger door mat pocket, is when I secured him in handcuffs behind the back and placed him in my patrol car.
Okay, was he detained or placed under arrest at that point?
Placed in handcuffs.
And then did you do anything else in this case?
Transported the defendant to the jailing facility for processing.
Okay.
Cross.
Officer, you arrived on scene, you indicated less than 2 minutes after Officer Colliver, is that right?
Yes.
How were you notified of this traffic stop?
I believe via phone.
Okay, did Officer Colliver contact you?
Yes.
He did?
Yes.
Okay, and he requested your assistance in this traffic stop?
Yes.
Okay. There was suspicion that this car was involved in narcotics, right?
Yes.
That's why you were called.
Yes.
And when you got there, you, at some point, you had your dog, right?
Yes.
And the dog circled and gave an indication of positive narcotics, right?
Yes.
Now, how long has this dog been in this field, I guess?
2.5 years.
Okay, and has the dog gave a false alert?
I wouldn't know that. There's been, can I elaborate? There's been instances where the dog gives a positive indication for narcotic odor. We don't locate anything during the search. I cannot confirm that that would be what I would call a false alert. Our dog's perfect? No, absolutely not. They're like humans as well. So, but I can't say that it's a false, if that makes sense.
Understood. So the dog may alert and something may not be found, basically. Understood. Now in this situation, he scratched and bit at the door. Is that a yes?
Yes.
That was at the driver's side?
Yes.
But narcotics were found in other areas of the car. Would you agree with that?
I don't know. I didn't conduct the search of the vehicle other than the trunk.
So you were just present when the narcotics were recovered from the from the driver's side?
Yes.
You were not aware of anything that occurred on the passenger side? Understood. The dog did not alert to the passenger side though, right? Now, when Mr. Seach was removed from the driver's side and placed in handcuffs prior to the observation of what you observed in the door, he was not under arrest at that point. Do you agree with me?
Can you rephrase that again?
Yes. So you had indicated that when you observed the narcotics, the first time that you observed the narcotics was when you were placing them in handcuffs. Is that right?
No.
No. When did you first observe the narcotics?
When I was patting him down for wetlands and then moving the knife from his pocket, he was not handcuffed.
Okay, so when you were patting him down, was he under arrest at that point?
No.
Understood. So he was just being detained.
Correct.
Okay. Then once you observed the narcotics, that is when the determination was that he was going to be arrested. As it related to the firearm, you had indicated that you found a loaded magazine in the trunk of the car.
Yes.
So you participated in some of the search of this vehicle.
Yes.
Did you conduct or did you prepare the tow slip for the tow company?
I don't recall.
Understood. So, but you wouldn't be the one that did that then?
I do sometimes, but I don't recall if I did.
If you did in this. Okay. Understood. I have no further questions.
Any other questions?
Briefly, and Officer Walker did gain indicate on any other areas of the vehicle?
So the driver that you were seeing.
Okay. Nothing further.
I have no other questions.
You can step down, sir. Thank you. Call your next witness.
Thank you, Ryan.
Thank you. Have a good day. All right, Detective, you can come on up here. Raise your right hand. You solemnly swear affirm under penalties of perjury the testimony you'll give in these proceedings will be the whole truth self you got.
Yes, sir, I do.
All right, have a seat, please.
Thank you, Your Honor, and good afternoon, Detectives.
Good afternoon.
Detective, could you tell us where you're employed?
Yep, I'm currently employed by the Police Department, assigned to the Michigan State Police Metro Narcotics Enforcement Team, which is a multi-jurisdictional task force.
How long have you been an officer for?
3.5 years and 2 years with narcotics team.
Okay, were you put into capacity on March 16th, 2025?
Yes, I was.
And at some point, did you become involved in the case of the people of the state of Michigan versus Charles Edward Siege?
Yes, I did, ma'am. I was notified by Brownstown Police Department due to the quantity of narcotics seized, that somebody that's full-time in narcotics with extensive training experience should become involved. At that point, I was contacted to run the case and conduct an interview with the defendant.
You stated that you ran the case or received this case?
Yes, I did.
And what did you do as well as see this case?
Essentially, I come to the Brownstown Police Department. I had a conversation with the arrestee where we discussed the case and what happened, and then I obtained the narcotics, get field tests done, send them to the lab, and then just kind of conduct things through the court process.
Okay, would you recognize the individual who spoke with you saw today?
Yes, I would.
Did you take a look around the court and point out and identify or calling that individual sorry?
Yes, ma'am. He said that seated at the defense table, wearing on her.
Your Honor, this time made the record like the one for Mr. Siege.
The record should so reflect.
Your Honor, you stated that
Wearing
you
that
have
guilty
a
shade
law
of green.
experience in narcotics. What is your experience?
Yes, ma'am. I conducted for my assignment to the Metro Narcotics Enforcement Team over 150 controlled substance incidents and arrests just on road patrol, which was the focus of my duties, which led to my assignment to the Metro Narcotics Enforcement Team, where I conduct numerous multi-state, multi-faceted narcotic investigations, large-scale distributors. My training includes full week training in narcotics, training from the Michigan State Police or Recovery Narcotics School. Desert Snow Narcotics and Addiction School, complex narcotics investigations in Florida, just a long plethora, master narcotics investigation by street cop training, a long list of narcotic-based investigation schools.
And are you familiar with indicators for narcotic sale and distribution?
Yes, I am.
What are the indicators?
A lot of times, what we're looking for is advanced team is scales, bags, multiple packages, over 100 grams of dope, or cocaine, fentanyl, whatever the controlled substance may be. Typically, these are indicators of a high-level narcotic distributor rather than, a user or lower-level citizen.
Okay, and you stated that you did have a conversation with Mr. Siege.
Yes, I did.
Where did that conversation take place?
Brownstown Police Department has an interview room within the booking area or their jail area. That's where the interview took place.
Okay, do you know if Mr. Siege was Mirandized?
Yes, he was.
How was he Mirandized?
I read Mr. Seach's Miranda rights directly from a UD 52 form, which is by the Michigan State Police, is their Miranda rights card essentially.
And did Mr. Siege understand his rights?
Yes, he did.
How was it you know he understood his rights?
He verbally explained or verbally stated yes when I asked him if he explained what I had read to him.
Did Mr. Siege appear to be under the influence of anything, alcohol, drugs, or anything else?
No.
And did he provide a statement?
Yes, he did.
And what is it that you guys talked about?
We talked about narcotics, where the narcotics came from, the amount seized. Mr. Siege informed me that he was indeed possessing narcotics, what he estimated to be 9 ounces of cocaine when he was in contact with the Brownstown Police Department, in addition to
What is 9 ounces?
9 ounces is approximately 250 grams, 252 grams to be exact, which did check out with the large bulk cocaine from my observation of the reports and my observation of the evidence. Right around that range, the large brick of cocaine that was seized from underneath the driver's seat was approximately 240, 245 grams, which is in the same ballpark.
Did Mr. Siege tell you what he does with this?
Yes, he did. Mr. Siege stated that he is a narcotic distributor. He sells approximately 9 to 18 ounces of cocaine per week, which includes the manufacturing of cocaine into crack cocaine.
And did you, Mr. Siege, speak with him about anything else?
Yes, we did. I asked Mr. Siege about the firearm located inside of the vehicle. Mr. Siege stated he does keep firearm on him for his safety while conducting narcotic sales.
Okay. And then regarding the stop of the vehicle, was that part of the conversation?
Yes, it was. Mr. Siege stated after leaving the Palace Motel, he felt tired and groggy. He did admit to crossing the center line, which was the reason for the traffic stop. He just told me that he was sleepy at that time and kind of lost focus while driving the vehicle.
Okay. And then did you and Mr. Siege speak about anything else?
No, just at that point, we ended up ending the conversation. The conversation was audio recorded and uploaded as evidence.
Okay. And then what else, if anything, did you do in this case?
I obtained the evidence. I did a preliminary field test on the suspected narcotics to confirm that they were indeed narcotics. I used a Searchy cocaine IV swipe, which is a pink swipe. Once you place it onto a substance you believe to be cocaine, it will turn blue if the substance does indeed contain cocaine. I conducted that in that office after obtaining the evidence.
Okay, who the suspected narcotics weighed?
I want to say, I just know just over 240 grams. I'd have to review the report to get you the exact number. But that was the large brick. There were multiple other small individually packaged bags that were seized inside of the car. At this point, without, they all appeared to be cocaine. I just tested the one for redundancy and the rest will go into the lab.
Okay, do you recall what the indication was when you did conduct the test?
Positive for cocaine.
And you stated that they were sent to the lab?
Yep, they were sent to the lab. They should be returned in the next couple of weeks.
Okay. And then was there a report for this preliminary analysis?
Yep, there's a preliminary field test analysis form that I fill out to show what test kit I used, the weight, and what the result of the test was. I did complete that and had it uploaded or passed along to you guys.
Could you recognize the form that we saw today?
Yes, ma'am, I mean.
Your Honor, may first witness?
You may.
And the fact that it's not marked as people's proposed exhibit number. We'll leave number 2. I'll leave the mark in the report. Do you recognize that I made here?
Yes, ma'am.
What is it that I made here?
This is the preliminary field test analysis form I was talking about.
And is this the field analysis test done, regarding this case?
Yes, ma'am.
Okay, does it appear to be an accurate depiction of the results?
Yes, ma'am.
Does it appear to be changed, altered, or manipulated in any sort of way?
No, ma'am.
And your honor, the sign dictated in Pickles proposes.
Any objection?
Judge, understanding the, rules governing preliminary examinations, I do not have an objection, as it relates to the preliminary exam only.
Peoples 2 is admitted.
And, what was the indication on that report?
Positive for cocaine.
And was the weight placed on there?
Yes, ma'am.
What was the weight?
244.3 grams.
Did you do anything else?
That's too much.
Investigating this case?
Too much grams.
No, not at this time. I just sent the rest of the narcotics to the lab, and that's it.
Nothing for this witness.
Any questions?
Just briefly, Judge. Detective, you indicated that Mr. Siege, had said that he crossed the WL line during the interview, is that right?
Yes, ma'am.
But actually the question posed was, do you know when you were stopped? And that's when he indicated, because I crossed the WL line. Do you agree with me on that?
I don't recall the exact verbiage that was said by Mr. Seach. I just recall him stating that he crossed the double lines.
And you would agree with me that upon your review of the evidence, the officer informed him of the reason why he was being stopped, correct?
I'm not sure if the officer informed, I can't speak to what Mr. Tolliver or Mr. Walker said during the traffic stop. I apologize.
But you did review the evidence in this case, correct?
Yes, the evidence didn't tell me what the officer said. I just didn't review every second of the body cam. I'm more concerned with the seized narcotics, the reports, things of that nature.
Understood. So you didn't watch. Then you're indicating to us today that you did not watch Officer Tolliver's body cam footage when he first approached the car.
Correct.
So I have no further questions.
Anything else? You can step down. Thank
Thank
you.
you, Judge.
Call your next witness.
Defense isn't calling witnesses, Judge.
People move the bind over. You agree this is a fact question,
I
correct?
don't, Judge. Actually, if I could just make a brief argument for the record.
Okay.
Your Honor, so I would argue that this was a pretextual stop, and I understand that pretextual stops are not illegal, that they're allowed if they have suspicions of something to conduct a traffic stop. But in order for a traffic stop to be conducted, there has to be reasonable suspicion. There has to be a reason as to why they are allowed to conduct a traffic stop to be lawful. Here, Officer Tolliver is alleging that the reason why he stopped this vehicle was because it crossed over a double yellow line. However, he has nothing to support that. There is no dash cam to capture whether this vehicle actually conducted this traffic stop that would allow them to have this interaction that they did involving a dog sniff and inventory search and everything that followed. Additionally, this court has to assess credibility under People v. Anderson. And in this situation, I think that we have to consider the credibility of Officer Tolliver. I asked, or actually the prosecutor may have asked Officer Tolliver, did you contact the canine officer? Did you contact Officer Walker? He said no, he didn't. They just showed up. However, when we asked Officer Walker on the stand, how did you arrive on scene? He said he got a phone call. And I asked him, did Officer Tolliver call you? And he said yes. So here we are having one officer discredit another officer. And that officer, that's very important in this situation because, Judge, we have to rely on that officer's testimony that Mr. Siege actually crossed over a double yellow line. That would be the basis for the stop. If that was unlawful, then everything that follows should be suppressed as fruit of the poisonous tree. We have nothing to support that. And so for that reason, Judge, I do think that this is a credibility issue. The court has to assess the credibility under People v. Anderson, and I would ask for this court to dismiss based on that reason.
Very
She's
good.
shooting for the moon. Very good.
That's just a brief response. I believe the officer's credibility would be still in question. In fact, he did state that these officers did arrive as backup for him. I don't believe that there was a misstatement by him. But having forgotten or whatnot, and not really sure the reason whether these individuals back up each other in multiple stops. Can't really argue that, Your Honor, because it's not testified to.
Here's the facts, though. Here's the facts. The officer testified
That he saw.
that the defendant crossed the yellow line. There's even testimony that the defendant later admitted that. And whether he has in-car cameras or anything else to substantiate it is not the issue. The issue is whether or not he observed the defendant committing a civil infraction. I think he was pretty clear and I found him to be credible. that he did in fact speak a defendant or observe the defendant committing a civil infraction. Therefore, the initial stop was proper. Everything that flowed with it was proper. I'm going to go ahead and bind the defendant over. I'm going to continue the 75,000 cash as surety bond. I'm going to give you September the 20th, July the 28th, sir, at 9 o'clock in the morning. You'll be there at the Criminal Justice Center. So July 28th, all other bond conditions set are continued. I wish you well. Good luck. Thank you very much. Do I have the domestic violence charge? John, can you get Mr.
I got it. Damn.
Lisa, can you bring in Sergeant Robinson?
Yeah, how's it going?
People against. Damian Deshaun Butler, 216-706-769. Your name, detective?
Judge Boyd's on break right now.
John Klein, Police Department.
Good afternoon.
Wait a minute. I'm calling this domestic charge.
Oh, this one?
We're going to bail on this
The
one.
in custody?
Oh, yeah.
That's Barda.
Well, Docs isn't even in here, and I'm not going to chase him.
All right, that's a different one. All right, that's where we're going to go on that one. We're waiting for Judge Boyd to come back. We're also watching Judge Raquel West's courtroom for a case that's going to start there shortly. So that's on my phone. We are in verdict watch. I still haven't given you the timer, but we are an hour and 47 minutes into verdict watch with Judge Boyd's sleepy murder court case. And I have to admit, I'm shopping for science stuff online. So I like the idea of teaching science classes for kids because then I get to buy the cool toys that I like playing with as well and teach the scientific principles of why they work the way they do. So there's a really cool magnet demonstration kit. And it comes with a couple pairs of magnets and some individual ones. And the magnets all have different properties. And some of the magnets just have strong attraction from a regular distance away. Like north and south poles, they stick together. And others attract until they get close and then they repel. And some repel until they get close and then they attract. And just doing things that you wouldn't expect a magnet to do, as we've actually had some developments in magnet technology. Why am I doing this? I'm not trying to do this. Why does it want me to enter my prime pin? Okay, I'm trying to figure out what's wrong with my Apple. Hang on one second. We're just going to go ahead and turn that off. Oh, that's this one. Never mind, I shouldn't have turned that off. That's this one I was worried about. All right, wrong remote. Give it a second, it'll be back. Let's see. I didn't buy a kit, but I helped my nephew build a working speaker. I like, for sound, I like to put a Bluetooth speaker in a 5-gallon bucket and stretch like a black garbage bag over the top and attach it with a big rubber band so that's stretched tight like a drum on the surface. And then I use my phone to play a tone generator so I can play any tone from way down below where you can hear, anywhere to way above where you can hear. And it plays that sound in the bucket, and it causes the vibrations to happen on the garbage can drum head, and you pour salt on the drum head, and it makes shapes depending on the frequency and the volume. So I like that one. That's fun. Do something with your black lights. I did. I gave them away. I put them out next to the street, and the people came and got them. Done with the black lights. What's the next case? This one was too sleepy. Less sleepy one. Oh, we like KiwiCo. I think we've got every kit they've ever done. Okay, turn on, please. There we go. Okay. This has to be input. Allow. it's working. Trying to keep an eye out for Judge Boyd. She's still on break. They also have some cool resonance speakers, like just a driver that you put on a surface and it causes that surface to become a speaker. That's a fun one. I'm trying to steer clear of some of the kits that just have everything involved in, set up. I'd like to sort of build our own. So if we're talking about flight for science, for this kid's science class, we'll have a fog machine that we can use to build a wind tunnel so you can see the aerodynamics of the smoke going over the wings and get that all set up. So a fog machine's pretty cheap. We'll get that, and a couple of the larger foam gliders, like the 2 or 3 foot span. I mean, sad no Radio Shack. Radio Shack, oh my goodness. My wife is glad they went out of business, basically. I think they're still around technically, but I'm glad they went out of business when they did, because we would be broke, like poorhouse broke, forever if there was a Radio Shack. I would spend all my money there. I once actually applied for a job there, but I didn't want to work on Sunday, and they wanted me to work on Sunday. That was my day off day. Being religious as I am, and they said, no, you have to work on Sunday. And they said, the no employee. I would have been your best customer and best employee. But no. Y'all are still doing school? We do school year-round. Yes. Soda bottle rockets are fun. You know what's even better? Dry eyes. No, never mind. AliExpress Radio Shack, and it's cheaper. Yes, but it just takes longer to arrive. Anyway, let's see. So Judge Dad has his domestic case going on right now. We'll let him be on that one. Which one is this? Oh, Judge Raquel West is just came on live. Let's see what's up here. Let's see if this is the case that we're waiting for. Brooke says you were number 344. That was you. You saw it as it happened. Thank you very much. Sensors and such. Do you remember the science kits back in the day where you could you'd buy this big kit and it was just full of every chemical that you could possibly imagine? It had these little white plastic bottles with red lids and labels on them. And they're like, this has sulfuric acid, and this has hydrochloric acid, and this has soda ash, and this, you had like 700 different chemicals, and most of them could kill you if you got it in your eye or drank it or anything else. And they just sell it on the shelf at toy stores. Those were cool. Man, they had some good stuff. Of course, the good things that make the reactions, you didn't have nearly enough. Like here we have iron filings, and you've got just enough. You put it on one magnet, you can never get it off, and it's done. Solar painting? Haven't heard of that. E-trial's coming up soon. Yes, so we're waiting for Raquel West's trial to start. I believe this is I think it's a murder trial. We even have a thumbnail for this one. We're trying to get Austin Drummond out of Tennessee. It's a quadruple murder trial that we're trying to get access to. In Tennessee, we submit paperwork and they just don't respond. So that's fun. Yeah, I love getting AliExpress stuff as well. Have some good components. If you're good at building things yourself, it's so much cheaper. History Channel has a show about the dangerous toys they used to have. Probably has the thumbnail for that show is the lawn darts. which is basically like javelin for kids' heads. That's I don't know. It's a terrible idea. I played them. Never once had a mishap. Those were the best. State v. Marks. When does that one start, Gigi? We might have to go to break and come back. Trying to see when this Raquel West trial starts. Judge Boyd still not back. Jury's going on 2 hours of deliberating. Note said Tennessee. When does it start though? When's the court? There's a lot of info we need to decide on a case. And just the defendant's name helps. But if we know the charges, the date that it's supposed to go to trial, the judge's name, the county name, the state, those are all things we have to research and put together to do stuff. Let's just go to break so we can do the new thumbnail. The new thumbnail looks great. I've got it right here. Let me see if I can pull it up for y'all. New thumbnails right here. That's the one we're going to be going to, I think. Also down in Texas. This is court right here. I don't know how late they run though. And I do have a thing tonight where I have to film my son doing Ninja Warrior stuff. So let's do this. Let's do Judge West on this one. Judge Raquel West. Where did her channel go? Not the shorts. .252 District Court 3. .252 District Court 3. There she is. Okay, we're going to put that there. Throw that on this machine. I need to record over here. Storage. Set network location, which isn't working. Just need to unplug it and plug it back in. Just plug back in. Hold, please. Now we have 18 hours to record. Okay, good there. So we've got Judge West set up. We are on verdict watch in Judge Simpson's court. Not Simpson, excuse me, Judge Boyd's. Got some parole hearings. What's Judge Wiggins doing? Let's check on him.
Bond to be set at $10,000 cash surety with those conditions. I'm also going to order a GPS tether on house arrest. Terms to be set by community corrections. Mr. Porter, if you are able to bond out, you are to come immediately to the community corrections office here at the courthouse and get signed up for your testing requirements and your GPS requirements.
Yes, Your Honor.
All right, thank you. Next arraignment.
We're still waiting for the verdict in the Judge Boyd trial. They've deliberated for 2 hours. I think we're going to go to a break. And we'll get our lunch, then come back. We'll see if we can get a verdict and start this Raquel West trial. Does that work? I'm hearing resounding yeses. What state is Texas v. Oh, I missed it. What state is Judge Wiggins in? He's in Michigan, I think. The seal looks like Michigan. So. But we're gonna go to break here and get this one done. Which means I need to make the new portal. Share, download, compress, download. All right, tonight when you go home, please hug the people you love, smile at them, and make their day just a little bit better. And please stay safe until we go live again. I'm looking at the time. It's 2 o'clock now. It looks like we'll be live probably by 3. Texas v. Freeman coming up later this afternoon. Live chat replay, subscribers, no on the live reactions, visibility. Give us. I'm going to put an hour on here. It might start sooner than that, but we'll do it. And we'll go ahead and put the portal up as well. State of Tennessee v. Parks. All right. Portal is set up. We'll see you guys after lunch.